morning, everyone. Welcome to the second day of our fall argument session here in Philadelphia. Today is September 11th, and I'm sure that most of us who are old enough can recall exactly where we were on that tragic day in 2001. I was on the bench in our courtroom at our state capitol in Harrisburg, and I remember it vividly. I ask that we observe a moment of silence to reflect on the devastating terror attacks that took nearly 3,000 lives, and to remember those we lost and the brave first responders who put their lives on the line. Thank you very much. While you're here, I hope you'll take a moment to observe the majesty of our Philadelphia courtroom and its tributes to our system of justice. Before we hear the first case, I'd like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a brief summary of the case. Please begin by stating your name and the party you represent and introducing your co-counsel to the court. The justices are familiar with the cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues if they so desire. I also remind you that we do not permit rebuttal. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. It rather indicates there are particular issues we want to explore further. While there's no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case. Good morning.
Good morning.
In this appeal, we consider whether our court should adopt the doctrine of quote-unquote intent-based parentage to determine whether a party is a parent in the context of a married same-sex couple and the conception of a child using assisted reproductive technology. Please proceed.
Thank you. Good morning. May it please the court, my name is Barbara Schneider and I represent the appellant Chanel Glover. And this court has granted an appeal on three issues. One is, as the court said, whether the holding of the Superior Court en banc conflicts with the holding of this court's decision in CG versus JH. There was also an issue as to whether or not that intent-based parentage should be applied to reach a conclusion that a oral contract established the spouse as a legal parent, the spouse who is an unrelated party. The parties were married. The parties conceived a child during the marriage, although there are several contracts involved here. The parties separated.
Explain what you mean by conceived in this context.
Conceived was the parties, Ms. Glover became pregnant with a child by assisted reproductive technology. The contract that permitted, I didn't want to recite all of the facts again, so the contract that permitted the conception, the contract that extinguished the sperm donor's right, relinquished the sperm donor's right to parenting of the child was a contract through Fairfax Cryobank. The signatory to the contract was the appellant. As the sole responsible parent party, the only signatory to that contract who was named as a responsible parent. There were no other contract provisions, and in the contract itself, it identifies Ms. Glover as the sole legal parent to that child. There were no other provisions in the contract that gave Ms. Junior any responsibilities, any parentage assumptions, anything that objectively looking at that contract, you could say this person intended to be a parent to that child, assume responsibilities, and I think in contrast, the case that we refer to as a Superior Court case, but it's in re Baby S, where through every step of the process that these parties undertook, and it was a heterosexual couple, but as you know, the law is evolving and revolving, and there's different parenting, family settings, but it was very, very clear in those contracts at each step of that, at each stage of bringing a child into this world, the non-related party, in this case it was the wife, agreed that an adoption was not necessary. She would assume parental rights of this child no matter what, put her name on the birth certificate, be considered the parent, take all of the responsibilities necessitated by a parent. That was done each step. It was assured that this child that the couple was bringing into this world, in its best interest, would have that assurance, because a lot of our estoppel cases and the concurring opinion by Judge Wecht and Judge Doherty in the CH case specifically focus on the best interest of a child, not the parties. It's not a commercial transaction.
Counsel, let's jump to the argument of intent-based parentage. What's your position on that?
My position is that intent-based parentage, especially in this case, is unwarranted here. I don't think it's appropriate. Because what you do is you take a nebulous intent, and I've read the concurrences and the majority opinion in CG. It requires more than people agreeing to conceive a child together.
Why?
Because in the best interest of a child, I think that the Commonwealth has an interest in assuring that somebody will take responsibility, somebody's ready to take the responsibility, and in all circumstances has said to the world, I am the parent of this child in an enforceable contract.
So share with us, based upon the facts of this case and what both parties did, why should this court not find that it was intent-based? They decided that they wanted to have a child, they contracted with the service, they hired a doula, they did everything that parents would do in preparation of a child. So share with me why this court should not assume that that's an intent-based parentage.
Because they did not contract.
And what was the consideration?
The appellant.
Let's talk about that.
Okay.
What would be the consideration in a contract for parentage?
Well,
we're going to promise to have a boy?
No, the consideration would be the assumption of parental duties under any circumstance, not if there's an adoption, not, this was at best case,
Your client engaged legal services for second parent adoption, did they not?
The clients engaged Journer law for an adoption after the child was born, and
how else would you adopt a child that's not born?
By the terms of the contract, it was if the marriage survived. And I believe that a big issue here that is being overlooked, in my opinion, I don't sit here and I don't have the authority, but when you talk about the best interests of a child and you talk about the assumption of parenting responsibilities, after the first trimester, which coincides with what we're arguing is an intent maybe to conceive a child, but not necessarily to assume and carry out parental responsibilities. If my client were to enforce something, I don't know what there would be to enforce if you take the flip side.
How would you handle the scenario if your client took her ovary and had it implanted in Junior?
That's a different issue because they would both be related. This
So you would say,
spouse,
when you say they would be related, there's parentage there.
there's parentage. This is a step parent at the best, okay? Non-related, did not assume responsibilities. If I read CG by the letter of the opinion, it required a substantial and an immediate interest in this child going forward, not in the conception of this child, not up to the date that we agreed to conceive a child and Ms. Glover became the sole responsible party, the only identified parent, the only enforceable contract party.
Counsel, let me follow up. I don't know that it'd be particularly fruitful to debate the facts. The facts are what they are, but a couple of times now you've characterized the dealings here in a way that seems at variance with what occurred. My understanding, you tell me if I'm wrong, is that the Fairfax Cryobank contract identified Junior as the co-intended parent, in quotes, the co-intended parent, and then that subsequently the care share agreement entered into, signed by both Glover and Junior, identified Junior as the partner in the care share, presumably care share of the child. So it seems you're resting a lot on a pretty fine-grained distinction. You want to insist that there was an agreement to conceive, but not an agreement to parent. But you also want to argue that intent should not be a factor because it's too nebulous. So I'm not sure whether you want to rule out intent-based parentage altogether. To the extent you do, characterizing it as nebulous isn't so much of what we do in family law susceptible to that characterization. Best interests of the child, for example.
Right. There's several questions in there. So it's not a care shares agreement of parenting the child. It's a financial agreement. It's a financial agreement as to payment for services. It's a we will jointly pay for this service. It doesn't, it sets forth the responsibilities under a contract. Ms. Junior is identified as the partner, not a parent, not an intended parent, the partner to Ms. Glover.
Is that, by the way, is that, in your understanding, altogether rare? It had been my understanding that in this field around the country, there are many times in which the gestational parent may be the only signatory, and the other intended parent may not be a signatory to a contract. But intent may nonetheless be there. Do you rule that out?
My answer is specific to this case.
Well, we're interested in this case, obviously, but
Yeah.
we're interested in more than your case.
Well, what I would point to is where it has been found to be an enforceable contract for two parents, and that's in Ray Baby S. The parties did not rely upon the contract necessarily that was just put in front of them to be sure that everybody was clear, I didn't mean to yell into the microphone, to be sure that everybody was clear what their positions were, what their intent was. They added provisions to that agreement so that it was clear in the best interest of this child that these roles would be assumed and carried out. And there are terms in family law that do seem nebulous, but the bottom line is best interest of the child. And what I would say specifically as in this case, the facts do not support an intent-based parentage for the very reason that, number one, best interest of the child. Number two, there was no specific contract term bestowing those rights, nor was there one made by the parties. And after the first trimester of this pregnancy, Miss Junior left. The parties separated. She went to, I believe it was Seattle, for a writing course, told my client, the appellant, that she would be moving out when the lease on the apartment expired, came back. That was after the first trimester. So what I would say is...
Counsel, can you share with us how those facts reflect upon a lack of intent to be a parent?
Yes.
Share with me.
Well, what I would say is in family court and in terms of best interest of a child, I think the court or the Commonwealth needs to be assured that there's a clear assumption of responsibility. Clear assumption. An adoption is not necessary, which it was in this case. It was intended. It was expected. The affidavits that the parties signed indicated that only after an adoption took place would Miss Junior be a parent to the child and then assume those responsibilities.
Counsel, I'm a little bit perplexed by your argument because I thought you were going to come in here today and argue against us recognizing or adopting the concept of intent-based parentage. You seem to be arguing more toward the facts that they don't support a conclusion of intent-based parenting, but we really need to determine what our framework is, the legal framework. So could you just go back to your position on this court adopting that framework?
I think the adoption of intent-based parentage, as this court said in CG, is not, I don't think it's a workable concept.
That's not what the majority said. The majority in CG said this case does not provide the court with a factual basis to make that determination.
Correct.
The court did not, the majority did not rule it out, and your brief indicates to the contrary. That's not correct.
The court says, and I can quote it specifically, I do apologize if it was misquoted by if the court believes it was misquoted. The exact quote is that CG contends our case law stands for the broad proposition that parentage can be established by intent in situations where a child is born with the aid of assistive reproductive technology. It does not.
Where are you reading that? Can you share with us?
That's on, I see that. It's on 442 and 905. Then the conclusion of the opinion, the majority's opinion, says, accordingly, this case does not provide this court with a factual basis on which to further expand the definition of the term parent. That's why we're here today. Because three of us were at least open-minded. I think the full court was open-minded, but three of us inclined, certainly two of us inclined toward intent-based parentage, and I thought that's why we took this case, to determine whether a majority stands for that.
Actually, it was three of us. I joined Justice Webb.
Yeah, but Justice Dougherty's concurrence was a somewhat different posture, but open-minded about it, certainly.
But the specific holding of the case was that it did not apply. That's the holding, and that the court also specifically said that Commonwealth permits assumption or relinquishment of legal parental status under the narrow circumstances of using assistive reproductive technology and forming a binding agreement with respect thereto.
Well, nobody denies, nobody here would deny, I mean, that happens every day with sperm donation. That's the other side of this. We're talking about gaining parentage, not renouncing it.
Counsel, is it your position that we should not recognize parentage by intent?
It is, and that it also does not apply
Here's the answer
in
to
this
the question.
case.
Well, I guess
I'm sorry.
if I could just ask the question, tell me why you do not believe that the Superior Court and the trial court were correct when they found parentage by contract. Because to me, and I may be possibly looking at this the wrong way, parentage by contract is a form of intent-based parenting. You can't accidentally enter into a contract. So what we're talking about is taking intent-based parenting by evidence by a contract and this idea of there being intent-based parenting without a contract. But here, every court that's looked at this so far has found a contract.
At least an oral contract.
Well,
Maybe
which I've not been told there's a statute of frauds issue here that you need to have a written one. So I guess the question is, why is this case the paradigmatic case to even explore extra contractual intent-based parenting if we conclude, as the courts that have looked at this concluded, that there is contractual parenting?
And that's where the three-judge panel, Judge Pellegrini's majority opinion, that's where it stopped. And my argument is, although it seems to be, because I'm answering the question, it seems to be a little dispersed, but the court had to find an enforceable contract under CG, because it says the narrow framework.
No,
Okay. So
you agree that you can have parentage, you can agree to parentage by contract. You can intend to be parents by contract.
as in Ray Baby S.
Okay, so you agree with that?
I do.
Here, the Superior Court found that was satisfied. There was a contract. The trial court found that there was a contract. All I'm saying is, if we find there was a contract, why is this case the case that we should be deciding, even though there is a contract here, even though the law says if there's a contract, there's parentage, we should venture into what intent-based, non-contractual parentage would look like in the absence of facts that show no contract. In other words, I'm kind of open to what intent-based parentage would look like, but we have a contract here. At least the courts below have said there's a contract.
The reason that subject was included and requested appeal of that was because that was part of the decision of the Superior Court in saying we did not, the Supreme Court did not specifically decide in this case whether intent-based parentage.
But it could be dicta.
It could be.
It could be dicta, because
It
if
could
there's a
be.
contract,
Because in my opinion and what I argued was that the Superior Court was not within their authority to entertain intent-based parentage. It had been ruled.
Say that. We made clear in NWM that the Superior Court has authority to decide the matters that come before it. They don't have the authority to countervail our opinions, but if there's a brave new world, they can go there.
Well, my argument is that it does conflict, which is what I argued in my brief, because of the statement by this court. But the Superior Court is an error-correcting court. So the error that they were tasked to correct was whether or not a contract existed as found by the trial court. And Judge Pellegrini found there was no contract, and then the en banc panel, in a divided decision, decided that there was. I have an issue with the finding of a contract to begin with and the assumption of an intent-based parentage as well as intent-based parentage in this case. So I've tried to cover all bases because I think intent-based parentage is a slippery slope. I think it tends to be result-oriented, which I believe it was by the Superior Court. I have nothing but respect for the Superior Court. I clerked on the Appellate Court. But I believe it has, I believe it opens a door to a lot of issues coming before this court that really need to be ironed out, I would say, by the legislature. I know.
Is it not? I suppose, you know, slippery slope arguments are often useful, but in the area of family law, we have a whole lot of slippery slopes. I mean, how to avoid a fact-intensive, credibility-based assessment by the finder of fact. Number one. And number two, since you mentioned the legislature, how much longer should Pennsylvanians wait for the legislature to give attention to assisted reproductive technology? Maybe you know something that we don't know about the intention of the General Assembly to legislate in this area.
I know from what I've read in these cases, I've read the cases, and the family law bar itself has waited with bated breath. I know there was something introduced that's been stalled, but addressing it on a case-by-case basis is a problem. It leads to result-oriented decisions such as
I don't understand the result-oriented decisions argument. I understand your argument that it may lead to protracted litigation,
Yeah.
but so what?
Both.
Because that just means that the courts are getting involved in really analyzing the facts of the case if we go with the intent-based parentage. But what do you mean they're results-oriented?
I believe that, and it was stated by the Superior Court on the en banc panel, how is this fair? How is not giving Ms. Junior parenting rights here fair? I think we need to strictly apply the law of contracts as it exists, and not, I mean, if I know the court has read the opinion of the Superior Court, we're talking about interpretations of contracts and picking flowery language that fit into finding a contract that I don't believe necessarily supports a contract in this case.
Counselor, you're conflating the Superior Court's opinion. They had alternative bases for their opinion. One was contracts plus the course of conduct established parentage in this case. The other was an estoppel argument.
Correct.
But they're two distinct bases for the opinion.
Correct.
The latter may involve fairness. The former does not.
And the issue with the estoppel argument is that, and as this court has viewed and discussed the estoppel argument, even in CG, the estoppel argument requires more than conceiving a child. It includes an interest in not just conceiving a child, but in taking care of, preserving, having custody of, having legal obligations to.
Counsel, wasn't that in fact the body of the December 21 affidavits each signed?
No, actually the affidavit said if the child is adopted, if we go through with a formal adoption.
My understanding, stating for their intent to adopt, Junior to adopt the son, co-parent with equal rights to Glover, and assume financial obligations if the couple should separate.
And if the child were adopted. The child can't be adopted, according to that contract, because the marriage broke up, which it did, prior to the birth of the child. There was no maternal, second maternal figure in
Your
there.
argument is that the key factor in a contract for this type of relationship is adoption. Is that what you just told us?
No.
Then why don't you tell us? Because that's what I heard.
No. My argument is that taken as a whole and looking at terms, which the Superior Court said these should be taken as a whole, and consider those terms as a whole, and the intent of the parties, considering the terms as a whole. There is no contract that binds Miss Junior as a legal parent to this child absent an adoption, and that was the intent of the parties. As expressed in all of these contracts, you start off with Miss Glover being the only legal parent, only one responsible, no other provisions. Then they agree to share the cost of the process. Then they go and agree to have an adoption if the marriage survives, there would be a legal adoption, and then, that's what the affidavits say. We intend.
Because I don't know in the record, where in the record does it say in the affidavits that an adoption must occur?
That's what the purpose for going to...
I'm asking you,
oh.
the writing of the affidavit, the contract terms, does it specifically say in that affidavit, and upon adoption?
It says... I understand that this means the child will have inheritance rights to Nicole Shawn Jr.'s property, will be eligible to receive Social Security benefits upon her death, and it's if the adoption occurs. I am seeking to have my spouse adopt this child in order to provide this child with the legal stability of two parents.
Where's it say it's contingent upon the marriage staying intact?
The contract that's included with the Journer Law Group.
No, you said it was in the affidavit.
No,
it
was the contract with the Journer Law Group.
Specifically says that this is only going to happen if the marriage stays intact.
Yes, because the representation of those two parties, there would be a conflict in that representation should they separate.
But the affidavit, which is her thing, doesn't say anything about the marriage staying intact.
No, but it does.
Simply says she intends her spouse, who was her spouse at the time, to be, at the time of the execution of the affidavit, to be the parent.
If an adoption occurs.
No, it doesn't say if an adoption occurs. It says I intend her to adopt. There's nothing contingent. I intend her to adopt if we remain married. It just says I intend her to adopt.
It also says we intend to remain a committed couple.
Sure, but that was her intent at the time she signed it, but there's nothing in the affidavit that says, oh, and by the way, everything in here is contingent upon us being married. In other words, if our marriage dissolves, our agreement to co-parent this child dissolves.
And that's the problem, and that's the issue with this case, is that it did dissolve, and there are no specific contract terms.
Counsel, as I reminded you, the December 2021 affidavit indicates spousal support or child support should the couple separate. So it was included. So share with me. You can't have it both ways.
I don't mean to have it both ways. What I'm pointing to is they are seeking to have her spouse adopt. And then...
I'm talking the affidavit.
Yeah, I'm looking at the affidavit.
They indicate that they will support, the exact, Glover will assume financial responsibility should they separate.
Right, to become a legal parent. But should the adoption not occur, this does not happen, and that is her agreement. That's the third prong of the agreement that the Superior Court looked at, is that as a whole, and...
You see the reach of your argument. If you're correct, any married couple that enters into arrangements like this with full intentions, memorialized as Justice Dougherty was eliciting a moment ago in these affidavits, in this affidavit in December 2021, and later the marriage dissolves as marriages do half the time, right? That globally you'd maintain that there's no availability of an intent-based parentage claim in such cases. It's not just this case. any case, and that's a breathtakingly broad concept, isn't it?
It is a broad concept, and until there are more, I would say, specifics, such as contract rights, until there's some precept that says this is what is encompassed by an intent-based parentage,
Suppose this was a couple that already had kids and they had raised these kids together, and they enter into this arrangement for whatever reason to engage assisted reproductive technology to conceive another child, and they memorialize it in the way Glover and Junior did, and they have the doula, and the thing proceeds as it did here, and then eventually the marriage dissolves. Under all such circumstances, you would maintain Pennsylvania law absolutely forecloses a claim to parentage. Is that what you're saying?
If there was, I would say, in my opinion, I'm not the court, but there is an opening if there is some intention beyond conception, some binding agreement or some explicit intent that there be an assumption. These parents didn't live together and the child wasn't born when this all happened. There was no child.
In January, Junior moved out of the shared bedroom, and in March she told Glover she was moving.
February she left, moved to Seattle. Shortly after the first, like into the second trimester. So when you talk about intent and when you talk about looking at which, Justice, I read your concurring opinion, which seemed to require more than conceiving. It was conceiving plus action.
Let me just probe you on that, and then I'll give you a break from me. I shouldn't promise that. You want us to expound a concept, I think, that in Pennsylvania law there is such a thing, whether same-sex couples, opposite-sex couples, presumably married couples, unmarried couples, of intent to conceive versus intent to parent. I'm not aware of cases anywhere which envision that people contract with one another to conceive a child, but not to parent a child. I'm not familiar with or how that would apply here.
Well, Your Honor, in your concurrence, and perhaps I didn't say it as eloquently as you did, but there needs to be more of a carrying through of a parental intent than just conception. That's what the issue with CG was. That was the issue with the other cases that I've read. But I believe Your Honor said, and forgive me if I'm misspeaking, that in addition to just conceiving a child together, there has to be more, either documentary evidence that is binding on the parties that will assure that both parties are legal parents.
We're sort of making this up a little bit, right? So what about this principle, which seems, to Justice Weck's point, a fair principle? We're not talking about agreeing to order a shelf from IKEA. We're talking about agreeing to bring a child into this world.
Correct.
What about a legal principle that says when two adults agree to conceive a child, to bring a child into this world, the law will presume their intent to parent unless they disavow it. So, for example, the contracts with the sperm donors require a contract where they give up, where the donor gives up parental rights. What about we say, if you enter into an agreement to conceive a child together, unless you disavow your parental right to that child, the law is going to presume your parents.
Then how does the Ferguson versus McKiernan work? Nobody, she didn't disavow. She filed for support, and this court enforced, in the protection of a donor, this court enforced that contract. But
That's a
I think it's opening.
sperm donation case,
Right.
And here, if you want to limit it to intent to conceive, then Junior's not a part of it at all in your reading, right? Because Junior's not a sperm donor.
That would open up the floodgates of, I believe, anybody, potentially one-night stands, potentially
How does that open?
break, conceive?
No,
go
you
in-
form, you, oh gosh, I didn't think this would get to one-night stands.
It could potentially.
I'm saying you have created this paradigm, as Justice Wecht has pointed out, that you agree they had a contract to conceive a child. You disagree that they had a contract to parent the child together.
I agree that there was a contract. The conception contract had my client solely as the responsible legal parent. So what I would say is, if this court required...
Well, okay, but that's an argument. I'm asking you, you agree that that the married couple had an agreement to conceive a child together. It wasn't a one-night stand. It wasn't, it wasn't, we're drunk, let's go to a sperm bank and see what will happen. I don't know how you can take a contrary position that they at least agreed they were going to conceive a child together as a married couple, right?
Right.
All I'm saying is, what about, if we're making this up, which we seem to be doing, what if we say, if you enter that kind of agreement, similar to how sperm donors have to disavow parental rights, we're going to say, if you enter into that agreement, if you go through the steps to conceive a child together and that was your intent, we, as a matter of law and as a matter of what's in the best interest of the child, we are going to presume you also intended to be parents, unless, like a sperm donor would, you disavowed it in writing.
I don't necessarily agree. I mean, it's a good question. I would tell you that I haven't, I would have to think it through, but I don't think in this case.
I don't want to, I'm not about this case.
In
I'm just
general?
saying, is that an unworkable paradigm? It may not be helpful to your client in this case. I understand that. You don't, but I'm asking you, see, that seems to me to see a bright line, clear, non-slippery slope pronouncement of law that tells everybody this is what's going to happen in Pennsylvania. If you enter in a contract to conceive a child together, then we are going to presume, as a matter of law, that you will parent the child together unless one or both disavow. Hopefully not both.
And in parenting the child together, you mean by support, custody?
Well, we'll deal with that if there's a dispute over whether one parent is being a deadbeat parent. But the point is, we're not going to leave these children in limbo that are being brought into this world about deciding where their parents are.
Right.
In the world of reproductive technology, if you agree to conceive a child, to create a child, the law will presume that you both also agreed to parent the child, unless you disavow.
All we're doing is advancing the definition of parent from traditional notions.
I understand.
So
I
that's
do
the
understand.
question. It's not about custody or support. It's should this court now recognize the concept?
And I understand that position.
And your answer is the court should not adopt the concept for these same-sex couples?
Well, I'm not even saying same. My paradigm doesn't even apply to the same
Not
sex.
same-sex.
It could apply to.
It would be in Ray Baby S, which is a heterosexual couple. It would be any.
But I'm asking you, 'cause I'm bringing it home to your issue.
My answer, quite honestly, is I would have to think of all the different scenarios, but I would say that I don't know how it would be enforced in cases such as mine. I know what you're saying, and I would say it's a good question, and that might be the way the law is going. That is not necessarily my position today. That's my best answer.
Are there any other questions? All right, let's hear from your opposing counsel. Ms. Watson?
Good morning. May it please the court, I am Megan Watson, and I'm here on behalf of Nicole Jr. I appreciate the court's consideration of this matter. The case law of this Commonwealth has clearly held that parentage can be established by contract in situations involving assisted reproductive technology. The decisions in the trial court and superior court to grant Ms. Jr. parental rights were based on such contract principles. Both courts determined that the parties entered into an oral contract with mutual assent, consideration, and definitive terms, being that Ms. Jr. would be the second parent of the child. The evidence supporting that decision is well enumerated in my brief and the decision of the Superior Court, and as Justice Brobson noted, I do not believe there is a question about that evidence or the application of contract law to these parties and the final determination of the Superior Court. So I would like to move on to the specific questions this court has presented.
Do you agree, counsel, that if we agree with that, that there's contract-based parentage, that this is not the case to explore extra type of contractual intent because the facts here support contract?
Absolutely not. This is the perfect case to apply intent-based parentage.
Okay. I mean, you got a contract, so I'm not sure what facts you have that give us. It would seem to me that explore intent-based parentage, whatever that is we would have to have a situation where there isn't a contract.
Well, I would disagree, Your Honor, because just because there might be one legal basis to find parentage does not mean that this court cannot find other legal basis to find parentage.
Except it's dicta.
Or we could make this the first intent in the contract part, the dicta. But, Your Honor, I would say that it's the purpose of finding intent-based parentage goes well beyond this case, as the questions presented here really have raised. There is a big gap in our law right now addressing the issues of ART and children that are conceived by ART, whether we are talking about heterosexual couples or same-sex couples. And this case is a perfect example of what happens because of that gap.
With regard to the ART, these are cases where you don't have the typical quote-unquote one-night stands, because the ART cases are cases where the couples have to give some deep thought to proceeding with this technology. It's complete with many documents that the parties are required to sign, financial commitments and obligations, and certainly in your case, there's the doula, there's a plethora of documents. And my problem, or my issue, I guess, with the intent-based concept in this case is that traditionally, when we look at couples who have children, and whether it's a one-night stand or not, to say, I didn't mean that, I didn't intend to be a parent, that doesn't work. So why should it in your case work where you have all these documents and now you're saying, but I intended to be a parent? If it doesn't work on one side of the stream, why should it work on the other?
Well, as Your Honor noted, you cannot accidentally get pregnant with ART, right? It is absolutely 100% intentional, and both of these parties intended to have this child. So because of that intent to have those child, and I may be misunderstanding your question, Your Honor, but because of that intent is so clear, because there's no accidental pregnancies in ART, well, there's documents in the case, and there are oral contracts, but it goes, Your Honor, it goes beyond that, because not in every jurisdiction and not with every sperm donor facility or every facility that does implantation do they have the same contract language. And parties, couples who choose to use something other than RMA, for example, shouldn't be prejudiced because the language of those contracts aren't as clear as perhaps the contracts were in this case.
So in your case, if your client intended to be a parent and you're then proposing that the court adopt as a grounds for finding parentage intent, should it also be a defense to parentage if your client then says, I didn't intend to be a parent, I just went along with the flow of it?
Absolutely. I absolutely agree, Your Honor. Intent-based parentage should be established both to support the rights of a parent, but also then to claim that this person is now responsible.
So then should couples that have a one-night stand then be allowed the defense that they shouldn't be required to be a parent to a child because they didn't intend to be the parent? I mean,
Well,
we're going to leave children out there without parents because I didn't intend it in this case, I did intend it in this case, and how can that be the law of
So, Your Honor, I would say they did the act, they did the deed to create the baby, that makes them the parent. They did the act, they contracted for ART, that makes them the parent. You do the deed, you become the parent.
Counsel, share with us your conception of the framework should we adopt an intent-based parenting.
Thank you, Your Honor, for that question. So I have proposed in my brief a standard for which we could, which like the best interest standard, right, would be a case-based fluid analysis of the particular circumstances of the situation before the court at that time. I do want to kind of identify, however, that I think that standard should be clear, that post-birth conduct, and I want to just talk about that for a second, can establish intent to parent, but it should never be used to negate the intent of a parent, which has been established either pre or post-birth. So if you have pre-birth intent to parent, and then maybe similar to this case, that person is cut off, you cannot then use post-birth conduct to negate the pre-birth intent. Okay, so as I said, in other words, once a parent, always a parent. So first, in my proposed standard is that the court should ask, are the parties married at conception? And that is exactly related to what Justice Mundy was asking, and that is you cannot accidentally get pregnant under ART. So I believe that the existence of a marriage at the time of conception through ART should conclusively establish intent and should end the inquiry.
What if the other spouse is not aware that the spouse went through ART?
So I guess in that situation it would be rebuttable. I'm trying to imagine a situation in which any facility would, at a time that parties are married, allow one party to do that without the consent of the other. I'm not familiar, but I guess it is possible that it could happen. And in that case, I guess perhaps it might be a rebuttable.
See, this is, I mean, I'm not going to interrupt your flow on your test. This is one of the reasons why I'm concerned this case is not the paradigmatic case, if there is in fact a contract. But I'll let you keep going, and then I'm going to come back and ask you about my test, which I think seems to be fairly simple.
Sure. If the parties are not married, I think the inquiry would continue, and the next question would be whether there is proof of intent for the non-caring parent to serve as the other parent to the child. That would also be a fact-based inquiry, which could be proved by demonstrating if there was significant participation during the ART process by way of the parties' behaviors leading up to, during the pregnancy, and also in assessing how the parties held themselves out to their families, to friends. Were they presenting themselves, as in this case, as both parents? Had they created names for each other? Were they calling both mothers, grandmother? And also, if applicable, after the child is born. But I would say, as I previously mentioned, post-birth conduct should not negate pre-birth intent. In my opinion, this standard, at least as a practicing family lawyer, is reasonable, it's clear, it's not burdensome, it's not chaotic, it doesn't require any more evidence than we would in like an in loco parentis case.
It sounds like parentage by estoppel. You're basically saying if they were married at the time and they held themselves out, then the one parent can't disavow. that they are a parent. That's parentage by estoppel.
That is one of the other legal concepts that was relied on by the Superior Court. And
No,
I
I'm
would
just
say,
saying your test sounds like parentage by estoppel.
yes, I acknowledge I would say it's similar to parentage by estoppel, Your Honor.
Can I ask you about your presumption? How would the presumptions streamline the fact-finding in the trial court? I mean, the same evidence that would rebut the presumption would also be used to prove that there was no intent to parent. I'm just thinking of, these wooden presumptions in our law, these presumption of paternity, et cetera. What do they actually gain for us? Why don't we just articulate a theory of parentage, of intent-based parentage, and instruct the trial courts to conduct the kind of probing evidentiary inquiry that presumably occurred here, without resort to these presumptions?
So I wasn't necessarily a presumption. What I'm saying is, in the cases where the parties are married and engaged in ART, it doesn't make sense to say that there was no intent. I mean, obviously there was intent. There's intent to create a child together. In those sorts of situations, like in this situation, that should be the end of the inquiry. Instead of going on to a full hearing that included the affidavits for the adoption, that included the contracts, that included all, emails, that's not necessary if they were married.
Yeah, I follow you. I mean, it's interesting, but so you're saying in this case, if it was done properly or in best practice, so to speak, going forward, Junior would have a tailwind. She wouldn't have had to establish what she established in the trial court because she'd be armed with the presumption you want to arm her with. And I guess I'm just wondering whether that would impoverish the fact-finding in these cases going forward in the trial courts.
I think it establishes a clear rule, which right now we don't have, and I also think it treats similarly situated families similarly, right? We don't question, unless someone's challenging paternity, when you're married, you're presumed to be the parent of that child that's conceived and born during the course of your marriage. Now, this court has, that marital presumption has been molded by this court in a way that it applies more towards when they're married, because that consideration is about the protection of that marriage and that family. I'm saying if we are child-focused in our case law and our custody laws, we should be focusing on the fact that these two individuals chose to bring a child into the world together and very deliberately did so, and therefore we should then say you are both parents, and the burden should not be on the non-carrying spouse to say, no, I really did intend to be the parent, or there was a contract, or we had these conversations, or look at my emails, or I was calling my mom grandmom.
Your test is creating a new, to Justice Weck's point, your test is creating a new presumption that would eliminate our contrast-based parenting analysis. This is not an alternative to contract. This is not, if we go your way, our contract-based parenting case law goes away because the burden is less. You don't have to show, as you just said, we don't have to get into agreements. We don't have to do anything. All we have to do is show that they were married at the time of conception and held themselves out to be co-parents. That creates a presumption that they are parents. And we don't have to get into contracts and agreements and affidavits and anything like that.
In ART cases in these circumstances, yes, we are talking specifically about ART.
We get rid of our case law that recognizes contrast. If we go your way, contract-based parenting goes out the window.
Only with regard to these ART cases.
Well, but we've recognized it in ART cases.
Right. So,
Right.
and I'm saying that
But you're not just asking for a new test. You're asking for a test that takes the place of contract-based parenting.
Well, in my opinion, it's an expansion of the contract-based law, case law that we've had in this case, and it clarifies, it makes it much clearer and much more realistic for regular families. I mean, These parties, if I can point out, were both lawyers, right? So they have a sophistication that is probably more than just the everyday parent, and even they couldn't get it right. We are here 2.5 years later. My client still hasn't met her son, and we are litigating this case. So contract-based principles for the everyday parent, they're not thinking, oh, you know, I'm married to my spouse, we're going to go with the ART, I have to enter into a contract. So I want to recognize how the differing ways in which families are created. And we should be valuing the way all of our families, whether they're created more naturally or whether they're created more intentionally through ART.
Counsel, can I ask you your view of the Superior Court opinion in this case? Because I think I might be reading it differently than some others. I'm just not as certain that the Superior Court decided that this is a contract-based parentage. As I read the Superior Court opinion, they looked at contracts to which these two people were parties engaging a third party to do something else. So it wasn't as though there was an explicit contract between just two people saying X, Y, or Z. I looked at the Superior Court viewing these contracts for evidence of intent to parent within those contracts. You know, the contract that indicated they were both intended parents. I mean, is that binding on either of them? Probably not. But, I mean, the Superior Court spent a lot of time talking about the language in the agreements and the course of conduct of the parties evidented an intent to parent?
So it's hard, Your Honor, because intent and mutual assent is one of the necessary provisions to establish contract.
Well, that's true, which brings me to Justice Brobson's statement very early on and again in this argument, because frankly it was my first reaction until I got into this a little bit deeper, that this case, anytime you have a contract, you're going to have parentage by intent, because the contract is going to establish the intent. So why are we looking at this as a vehicle to recognize parentage by intent? But the more closely I read the Superior Court opinion, I believe that they thought that to get to where they absolutely ended up in this case, they really did have to apply parentage by intent concepts to reach this conclusion. Bringing me to the point where I see this likely as an appropriate vehicle to address the issue we accepted this case on, which is whether or not we should recognize the doctrine. But am I wrong? Do you think that the Superior Court actually said, oh no, there's clearly a contract between these parties?
I do think so, Your Honor, and I think all the judges on the Superior Court said so, the majority and the concurring opinions. I also think they all believed that this was a perfect case for intent-based parentage, with the concurrence saying, but we aren't comfortable deciding it at our level, we are leaving it up for the Supreme Court. I think across the board, all the judges on the Superior Court were in agreement, both on the contract, the oral contract that existed between the parties, and on the fact that this would be a good intent-based parent. And
there's no, I don't think you can read them any other way. I don't think there's any dispute about that, what happened in the Superior Court here.
I would agree with you, Justice Wecht. I think, Justice Donoghue, the issue I have with just continuing under contract, using contract law, is really an issue of equity, because we are then very much treating our families differently.
No, but the problem is, and maybe we do this, I don't know, I'm not very comfortable with it, but you may have a very good argument that we should recognize that even in the absence of a contract, there may be circumstances where this court should recognize parental rights in an artificial conception case. But if this case is on all fours a contract case, then we don't have in front of us a factual scenario to tell us, give us the example of the non-contract case to find intent-based parentage. And the Superior Court pretty clearly said, we find that Junior has an enforceable right to parentage under principles of contract law. Certified record demonstrates the parties' mutual assent, actions in furtherance of sufficiently definite terms of the agreement, and consideration. So I'm sympathetic to your desire that we proclaim some other option. But as a judge, I need to know what the facts of your client's circumstances are such that that other option presents itself. Because right now, under current law, you probably win. So, or you have won. Nobody's taken your victory away from you yet. You've already won twice.
So, Your Honor, I would say, specifically with this case, is evidence of why, if, for example, we had in place what I'm advocating to have in place, that when the parties are, if the parties are married at the time of conception, that would have allowed us, we would not be here 2.5 years later arguing about standing and whether she was a parent. We would have had a custody hearing. My client would have been able to see their son. We would be in a very different place had this legal concept been, had it been established at the time.
Yeah, had our precedent on contract-based parentage not been there. This is really what you're arguing. Your argument at base is for us to discard contract-based parenting and go with just intent-based parenting. It's not adding an additional test. It's you think it should be easier, and you think contract-based parenting is too difficult.
Yeah, yes,
but you
exactly
won.
Right, Your Honor.
You won. If you weren't the winner, that would be one thing, but you won.
So we won legally. My client has not won in her life. She still has not met.
Well, and I'm sad about that. I think I don't, but I'm not here reviewing custody injunctions or orders of the court granting her visitation. I'm not here reviewing any of that stuff to decide whether that is appropriate or inappropriate.
Well, none of that has happened because of these appeals, right? So we haven't gotten to any custody decisions, none of that has happened. And again, so yes, I am saying that in situations of ART, I believe intent-based parentage is a much cleaner and better standard than the current law under contract.
Any other questions? Thank you, Ms. Wolf.
Thank you, Your Honor.
Mr. Minner?
This is yours.
Oh, that's an auspicious start. Thank you.
Good morning.
Good morning, Your Honor.
As part of its stormwater management system, the Borough of Westchester imposed a stormwater charge on developed properties in the borough, which is calculated based on the impervious surface area within the developed property. The Pennsylvania State System of Higher Education and the Westchester University refused to pay the borough's stormwater charge, alleging that the charge is actually a tax from which the university is immune, and the borough sought declaratory relief in the Commonwealth Court. That court granted summary judgment in favor of the university, finding the stormwater charge was a tax because, among other considerations, the funds received from the stormwater charge benefit the community as a whole, and the university does not receive a discrete benefit from the borough's stormwater management system. The court further concluded that the stormwater charge is not a permissible service fee because the borough did not demonstrate that the fee is reasonably proportional to the value of the benefit received by the university. In this direct appeal by the borough, we address the propriety of the Commonwealth Court's conclusions. Please proceed.
Good morning, Madam Chief Justice, members of the court. May it please the Court, my name is Michael Gill, and I am joined by my co-counsel, Alexandra Roberts. I will be arguing the entirety of the case on behalf of the Borough of Westchester. Before I begin, I would just like to note that I am wearing an insulin pod, which may beep during my presentation. I have not yet, despite having it for a number of years, figured out how to stop that periodic beeping. The Borough of Westchester respectfully requests that this court reverse the order of the Commonwealth Court, which granted summary relief to the state system of higher education and Westchester University, and denied such relief to the borough. The issue in dispute is the characterization of the borough's stream protection fee as either a fee, which of course the borough asserts it is, or a tax, which the state system asserts. In holding for the borough, this court will join a number of other state and federal courts which treat stormwater fees as such and not as taxes. This case, as most of the cases before this court are, is of far greater significance than the approximately $130,000 per year which the state system of higher education has not paid to the Borough of Westchester since the stream protection fee program was implemented in 2016-2017. As demonstrated by the considerable number of amici in this case, this court's resolution of the issue will have statewide ramifications between municipalities, which must manage stormwater flow, and the exempt and immune communities, property owners within those communities. Will the immune property owners and exempt property owners who enjoy the benefits of connection to municipal stormwater systems enjoy those benefits without having to pay for them? And if so, who will? There are two fundamental truths in this case. Firstly, stormwater flows. We so far haven't figured out any way to stop that. And it flows from developed properties. And then when it does flow from those developed properties in a manner which differs from the natural flow of water, which is often the case in development, someone must manage that flow. You cannot simply discharge stormwater downstream when you have altered the natural flow of that water. There's the beeping. Another undisputed fact in this case is that stormwater which flows from North Campus at Westchester University is collected by the Borough Collection and Conveyance System and is conveyed through that system to a receiving watercourse. That fact is undisputed. Water, and I'll say it again, water from Westchester University's North Campus enters the borough's collection and conveyance system and is collected and conveyed to a receiving watercourse. The borough's expert estimated the volume of that flow on an annual basis to be approximately 32.5 million gallons. Here, the state system of higher education and all of the property owners, all of the owners of developed properties within the Borough of Westchester, an important distinction, the borough only charges the fee to developed property owners, not undeveloped properties. Here, the state system and all of those other property owners can rest easy. They do not need to figure out how they are going to get their stormwater from their property's edge, from the low points on their properties, to a receiving watercourse.
Council, just a clarification, when you say all developed properties, you mean residential and commercial?
Yes, Your Honor. A developed property is a term defined in the ordinance, essentially, generally, as a property that has man-made alterations to it.
And the calculation is the same for the, I'll say, charge, fee, tax, I don't know, we'll figure that out, is the same for residential as it is commercial. It's based on impervious surface.
The calculation is the same. It's $6.70 per 1,000 square feet of impervious cover, and there is a tier system set up to establish properties into 6 separate tiers based on the amount of impervious cover at each property, and then the charge is based essentially a multiplier or a divisor of the base fee from there. But at the core, the calculation is based on the amount of impervious cover at the property.
Times a multiplier.
Times a multiplier.
And the multiplier is based on what?
The multiplier was originally determined by, or recommended by a Stormwater Advisory Committee, which worked in the borough over a period of time to develop this program.
That tells me who created it. The question is, what is it based on?
It's based on the projected costs by that committee, as recommended to Borough Council, for the costs of operating the borough system, plus the cost of future stormwater projects which the borough would undertake. And the Stormwater Advisory Committee, and then recommended to Borough Council, had essentially a menu of projected future projects to enhance the stormwater management system in the borough. There was, the Cadillac. There was the, I'm going to do away with that analogy because I'm not good enough with cars. There was the high level, the medium level, and the low level, and I believe that they ended up somewhere just with a fourth option between medium and high. And then they determined the amount of revenue that would be needed to carry out that program. They estimated the amount of fees which would be collected from the developed properties in the community, and that led them sort of through reverse engineering to the $6.70 fee.
Now, if I remember the ordinance specifically defines what is included in the borough system. Is that correct? There's a specific definition of what the borough system is.
If I may, Your Honor. The stormwater management system is defined in the ordinance, and this is in the record at page 55A, as a system of collection and conveyance including underground pipes, conduits, mains, inlets, culverts, catch basins, gutters, ditches, manholes, outfalls, dams, flood control structures, natural areas, structural and non-structural stormwater management best management practices, channels, detention ponds, public streets, curbs, drains, and all devices, appliances, appurtenances, and facilities appurtenant thereto, used for collecting, conducting, pumping, conveying, detaining, discharging, and or treating stormwater. So essentially an entire unified singular system of, to boil that down, methods for capturing stormwater through inlets and conveying stormwater through pipes, ultimately to receiving water courses.
So the reason why I asked you that question was I wonder whether there's factual issues in this case, but and whether the Commonwealth, that's where I'm kind of wondering whether this was a premature grant of summary relief. There's sort of genuine issues of material fact. In terms of the fee that is being charged to Westchester University, you had indicated in your opening that the stormwater at that facility goes into a grate, gets conveyed by a pipe to a water discharge on a waterway, correct?
That is correct, Your Honor.
Is the fee that you are imposing on Westchester to recover the cost for that conveyance of that water through that pipe to the water course, or is the fee being used for some greater, larger purpose unrelated to the system that the borough, that the university is actually using?
Thank you. That is an excellent question, and one that's really at the core of this case. The university, the state system, asserts that unless the borough is using the dollar that it collects from the state system to work on the stormwater collection and conveyance system directly adjacent to the university campus, that somehow this can't be a proper fee. Our position, of course, is the contrary. We have a singular, comprehensive stormwater management system in the borough. It has never been the law of this Commonwealth, as far as we are aware, that you must use, if you collect $100 from a property owner for a fee, that you must use that $100 to specifically benefit that property owner. And if you only use $50 to benefit that property owner, you must refund the $50, the other $50 to them.
I don't think that that's what they're saying. I think, or at least that's not how I read it. I think, my question is, and I wonder whether the Commonwealth Court opinion wrestled with the facts, are you entitled to assess a charge for the use of the system, which I suggest you probably are, just like using a sewer system or a water system. But does your fee, does your structure collect revenue to pay for things outside of the system, beyond the system? And your argument clearly is no. I understand you believe no, but I just wonder whether there's a factual issue there that was in dispute that should have prevented the Commonwealth Court from entering summary relief.
Our argument, of course, is no, Your Honor. The Stormwater Ordinance, the Stormwater Protection Ordinance, which is the genesis of the fee, expressly requires that all of the revenue from the stream protection fee be deposited into a stormwater fund.
Right, but the fund can only be used for certain purposes.
And then the fund can only be used for stormwater-related purposes.
Can it be used for replacing the system or just maintaining it?
If I may, Your Honor.
To the extent there's a difference. What was the question?
The Stormwater Management Fund, this is Section 9 of the enabling ordinance at page 58A of the record. All sums collected from the payment of the stream protection fees shall be deposited into the Westchester Borough Stormwater Management Fund. The Stormwater subsection B, the Stormwater Management Fund shall be used by the borough for implementation and management of a program to manage stormwater within the borough, constructing, operating, and maintaining the borough's stormwater management system, debt service for financing stormwater capital projects, and for payment of other project costs and performance of other functions or duties authorized by law in conjunction with the maintenance, operation, repair, construction, design, planning, and management of stormwater management facilities, stormwater facilities, programs, and operations. Though that does not expressly contemplate replacement, I would argue here today that it's inherent that if a portion of the system fails, if a pipe degraded, and that needed to be replaced, that would be a valid use of the Stormwater Management Fund.
So I'm glad you brought up that provision. Construction, operating, and maintaining the borough system. And again, that's a specific defined thing, the borough system, correct?
Yes.
So that's two. But this fee can also be used for managing a program generally, not just the borough system, a program generally. Debt service for capital projects, which may or may not be related to stormwater capital projects, which may not be related to the system, whatever we define the system as, and other things. I'm not saying these aren't all stormwater related. I'm saying that as I read your ordinance, I'm wondering, is there a distinction between the system that they are using, of which you should be entitled to do a fee, and general stormwater things you might be doing around that you can use the fund for?
Well, of course, the borough's position is that this is a broad read of the empowerment, that if there are things which benefit the system, That could be under the MS4 permit, the borough's MS4 permit. That could be public outreach. The university, as we'll get to in a moment, has its own MS4 permit, and part of that permit is
relies on the borough system. Yeah,
it does. Yes.
But is planting is digging a swale on the opposite side of the borough and planting trees something that the borough or that this fee that they're paying for?
Yes. Yes, because we have a single comprehensive system, stormwater management system within the borough. And though there are two separate watersheds, there's Goose Creek and there's Plum Run, excuse me, that the stormwater, because of the way topography is in the borough, stormwater runs to, we essentially have a single comprehensive system. So improvement to one part of the system benefits the entire system. If we want to get philosophical, just the same way a butterfly flapping her wings creates some wind effect some part away, I would posit that this is much closer, much less attenuated than that. I'll also point out...
Counsel, can I tease out that particular argument?
Certainly.
Because Justice Brobson's asking you about hypotheticals, you're talking about butterflies. Was there any evidence procured in this particular litigation regarding the historical uses of the money? In other words, did Westchester University engage in any discovery where they looked at your historical uses of the fees that were generated and said, these weren't really for stormwater management, these were for programs unrelated, which is what I think Justice Brobson's asking you.
Yeah,
Capital programs, programs unrelated to stormwater management, because to me, instead of engaging in kind of a series of hypotheticals, it would be useful to the court, and I guess to the trial court, for you to produce or somebody to produce discovery regarding when the fee was implemented and all of the uses of those particular fees, because if I'm the university, I'm going to challenge the use on that basis, right?
Yeah, so there is discovery to that effect. There are affidavits from the former director of public works at the borough. There's an affidavit from the borough finance director. There's deposition testimony from the university, from university employees, state system employees, excuse me. There's deposition testimony from the borough manager. But again, at the end of the day, we have a single comprehensive system and no legal requirement of which we are aware that says you must spend dollar collected from this property owner only to benefit that property owner.
I'm not talking about property owners. I'm talking about general uses. If Justice Brobson's talking about kind of programs that are outside stormwater management, capital expenditures outside of stormwater management, if I'm Westchester and I'm saying, well, this is kind of a tax as opposed to a fee, you're going to argue the fee is only related to stormwater management. I'm going to give examples, if I'm the opposing counsel, of historical uses of the monies collected for uses unrelated to the management of stormwater management. You understand what I'm saying?
And that may well be an appropriate fact-finding inquiry that the Commonwealth Court must conduct. What is the use of each dollar or each tranche of dollars, or for every year, what was the money used for? Again, our position is that, at the risk of belaboring it, is that we use every dollar that is collected from the stormwater management fee, from the stream protection fee for the stormwater management system. That does not necessarily mean that every dollar is used for the pipes in the ground, the inlets in the road. I'm not suggesting that, but every dollar should be used for, under the ordinance, should be used for stormwater-related purposes, for the purpose of constructing, maintaining, operating the system and related programs.
You're saying that the record does not suggest otherwise.
We certainly do not believe the record suggests otherwise.
Was there any argument to the contrary by the university? Or would you prefer that I use that particular question to your opposing counsel?
I'm sorry, Your Honor, would you please say?
Was there any evidence or suggestion or argument made by the university that it was?
Yes. Yes, there is. And that argument, at the risk of stealing Mr. Kavadas' thunder, that argument essentially is that there are stormwater infrastructure programs going on in other parts of the borough, and how does that benefit the university?
But that's a different question. I mean, there are two different questions. Does the amount gathered in any way specifically benefit the university? Or the second question, the amount gathered, is it solely used for stormwater management and repair purposes? Now, the second question is the one I was pursuing, and I think you said there's no evidence otherwise.
We don't think there's any other evidence otherwise, short of a characterization of something not having to do with stormwater. Somebody could stand up and say, well, a rain garden in the northeast corner of town is not a stormwater-related program. I would disagree with that, but they could say that.
That's not a fact. I mean, they haven't established that in the case.
I don't believe so. I would, before we move on from this point, I'd like to draw an analogy to Section 5607 of the Municipal Authorities Act. Now, the Municipal Authorities Act, of course, at Section 5607, has a very long list of powers of municipal authorities. And Section D9 of 5607 empowers, the General Assembly empowered municipal authorities to charge usage fees, which is essentially what we're talking about here, for the payment and expenses of the authority, the construction, maintenance, repair, and improvement of sewer systems. Treating the system, or if you're in a municipality that has sub-sewer districts, treating the sub-sewer district as a whole. And again, I want to stress this. I am aware of no legal requirement, nor apparently is the General Assembly with regard to municipal authorities, that says you have to use the money adjacent to or on the property of the fee payor. You can use the money to fund the system. So as I was saying, we have the undisputed fact that water flows into the system, and of course the Commonwealth Court held that that is not a benefit. Before the Commonwealth Court, the state system argued that it does not need the borough's stormwater collection and conveyance system because, and I quote from their Commonwealth Court submission, there is no reason the university could not simply convey to stormwater to its property's edge and discharge it there as it does now. There are two problems with that logic. Firstly, it's legally incorrect, as I'll get to in just a moment, with your indulgence. And secondly, the as it does now is very telling, because as it does now, the borough collects that stormwater and conveys it away. Now, why is it legally incorrect that they couldn't do that? There are at least 4 bases for the university, for the state system's obligation to make sure that it doesn't just discharge stormwater to its property's edge and let it flow from there. Those are common law, statutory law, constitutional law, and the borough and the university's own MS4 permit, which I presume you will hear about in just a moment. Under common law, as early as the middle of the 19th century, as far as we were able to discern, if not earlier, it has been the law of this Commonwealth that you cannot alter the natural flow of water coming off of your property in a manner which is disadvantageous or adverse to your downstream property owners. So we start with this very ancient rule. You can't just develop your property and say, the heck with it, you deal with the stormwater coming off of my property. Statutorily, the Stormwater Management Act proscribes the discharge of stormwater downstream in a manner which is disadvantageous or adverse to downstream property owners. This court is very well familiar with the Environmental Rights Amendment. I posit how an agency or an instrumentality of the Commonwealth could take the position that it could just discharge stormwater to its property's edge and let it flow where it is wont to flow. And then finally, their MS4 permit. As a university, as an institution, the Westchester University is required to have an MS4 permit. The testimony, some of which we cited in our brief, And the documentary evidence in this case makes clear that the university relies upon the borough stormwater and collection system in order to comply with its MS4, with the university's MS4 permit obligations. In other words, they must have somewhere to discharge their stormwater under their own permit, which they argue is a reason to not find that they benefit from the university system. But the very terms of that permit, or at least as described by documentary and testimonial evidence, is predicated, that permit is predicated upon the existence of the borough system. So we reach a conclusion here on the benefit side of this analysis. And I didn't really get to the three prongs of the analysis, but we have to identify, is there a service and benefit? Is the use of the service and benefit voluntary? And is the fee proportional to the value of the service or to the cost of providing the service? On the benefit side, we think it clear that the Commonwealth Court, in relying upon a single trial court opinion from the Federal Claims Court in DeKalb County versus the United States, got it wrong. We just think that the Commonwealth Court got it wrong by not seeing the existence of the municipal stormwater system as a benefit to the owner of a developed property. Interestingly, before I move on to voluntariness, the Commonwealth Court did not note, even though they relied upon a 2013 Federal Claims Court decision, they did not note the 2019 decision of the Fourth Circuit Court of Appeals in Norfolk Southern versus City of Roanoke, where the Fourth Circuit held that stormwater fees are just that, fees and not taxes. Of course, this court's not bound by any of that. With regard to voluntariness, we note the existence of the credit program within the ordinance. Property owners may obtain a credit against the stormwater management fee for improvements to their own properties which reduce the amount of stormwater which flows from their properties or treats the stormwater before it leaves their properties.
I think that was an interesting point that you raised below. How, if you can't meter the stormwater, you can't have a fee system that meters the stormwater going into the drainage pipe. How are they supposed to meter how much stormwater they can divert?
Well, the amount of stormwater which they, how can they matter how much they can divert? It does, the credit program, Your Honor, does not look at how much volume has been diverted. What it does is say, have you done things which, because of known engineering practices, are known to reduce the volume of stormwater. In other words,
no matter how great, no matter how small.
I don't know, Your Honor, and I apologize, within the fine gradations within the credit program, but I can give an example. Westchester University's library, the F.H. Green Library, has a green roof. If the university came to the borough and said, we have a green roof, and by the way, they do an awful lot of other really good environmental things on campus. But if they were to come to the borough and say, we're doing all of these things, including our green roof, we deserve a credit against our fee, I imagine that would lead to a rather substantial reduction of the fee.
Well, I guess that's my question, is how do you calculate that?
The appeals manual has the appeals manual has the methods for calculating that. I don't believe it's just willy-nilly discretion for the borough manager to decide how much of a credit you get.
For example, your fee is based on impervious surface, and then you have a multiplier, right?
Yes.
So I would expect, and I mean, if the field manual's in the record, I look at it, that the credit system is also based on impervious surface.
Yes, there are calculations in the appeal manual. On page, and the appeal manual runs from page 1915A, including the actual application and the appendices, to page 1981A. And just flipping to page 1930A, there is a section entitled Calculation of Non-Residential Credits. And if I could read the calculation, for whatever that's worth, stream protection fee credit, SPF credit, equals treated impervious area divided by 1,000 times credit percent by type times stream protection fee. So there is a formula there. It's not just unlimited discretion.
It's based on the size of what was previously impervious surface
versus what they've either versus the amount of treatment or volume reduction through various BMPs, best management practices that they're able to
Wouldn't that just be
implement.
a reduction in impervious surface? If I have a 50,000 or 100,000 square foot asphalt roof, that's impervious surface. I'm going to pay a fee based upon the impervious surface. If I put a green roof on there, aren't I just reducing my impervious surface and thereby reducing the fee?
Yes, so there are both credits and appeals within the program. And if you can demonstrate that
In other words, they've got a big parking lot out there, right? That's part of the impervious surface. That's part of the fees calculation. If they ripped up the parking lot and put grass down, it would reduce the impervious surface, right?
Absolutely, Your Honor.
The fee would then go down.
That's correct. So the amount of impervious surface that's used in the first instance to calculate the fee is taken from Chester County GIS data.
Right, and that's always subject to kind of recalculation.
Yes, Your Honor, absolutely. If a property owner comes to the borough and says, those data are wrong, the county's GIS is wrong, that doesn't capture the fact that last year I ripped up my swimming pool and returned my backyard to entire green area, then that would lead to a recalculation.
Mr. Gill, you've been doing a great job answering all these questions, but I think we've got the case, unless there are other questions.
I lost the connection of the responses you were giving to my colleagues in the last couple of moments. Is there a tie between, is there a connection to the concept of voluntariness? Because you were talking about voluntariness and then you got a question and I lost the connection a little bit.
Thank you, Your Honor, for allowing me to return to voluntariness. As I said, the state system could reduce its fee, and if the state system demonstrated that it discharges its stormwater outside of the borough under a change to the appeals program, which did happen during the pendency of this case, I want to be clear about that, then they could eliminate the stream protection fee altogether. I do want to, in all candor, I do want to make the court aware that there is what appears to be an inconsistency. Language was added to the appeal manual after the commencement of this case to say, if you drain outside of the borough, you are not a developed property and you don't pay the fee. There still is language in this manual which caps the reduction at 60%. And that language, I believe, as I stand here today, that is an oversight. It would certainly be my advice to my client that if you demonstrate that you drain entirely outside of the borough, in other words, you don't rely upon the borough system.
Would it be akin, I'm sorry to interrupt, just conceptualize that. Would it be akin to I opt out of my municipal trash collection because I'm going to take it to some dump somewhere and I establish that to get out of the fee, or I put in a septic plant on my own property so I'm not tapping into the sewer system?
I think that is a very apt analogy. Without getting into the weeds on what Act 537 would or would not allow you to do from a sanitary sewer perspective, I think that's a very apt analogy.
Can I just follow up real quickly on that one point you said? Discharge outside the borough or outside the borough system?
The appeal manual says.
I don't want you quoted outside the borough. Are you suggesting that if they were able to get a discharge permit for an on-site system that discharged into a stream, you consider the stream part of the borough system?
No, my interpretation of that, and that is exactly the situation that the Borough's expert contemplated for their expert report. It would be that the university builds its own collection and conveyance system and then discharges directly to a receiving water course.
But that receiving water course could be in the borough.
It could be,
right.
but
not part of the
that would
borough
not be
system.
part of the borough system.
Just wanted to clarify that. Thank you.
All right, are there any other final questions? You can wrap up if you'd like, Mr.
Thank you, Your Honor. I did just want to touch on that issue of proportionality, which I didn't get any questions on, but if I may. Justice Brobson in 2015 wrote at the Commonwealth Court in GSP Management Company versus Duncansville Municipal Authority, and I'm paraphrasing, that precise proportionality is not required. It is not the borough's obligation to show that we are using every single dollar of the stream protection fee for stormwater management purposes at this particular property. So long as there is some reasonable relationship between the cost of maintaining the service for all customers and the customers challenging the rates received some benefit from the system, proportionality is met. There then, of course, is the underlying question which the Commonwealth Court directly addressed of the use of impervious surface as a proxy. We know of no other means by which municipalities or municipal authorities can establish the volume of use or the scope of use of a municipal stormwater system. We know from various Commonwealth pronouncements, including Chapter 102 of Title 25, the Environmental Code, we know that the Commonwealth sees a direct relationship between impervious surface and stormwater runoff. So again, we think respectfully the Commonwealth Court just got it wrong in saying that there is no relationship between impervious surface and stormwater runoff.
Okay, thank you, Mr. Gill. We understand your argument, and I believe you made it as interesting as was possible.
Thank you, Your Honor.
Doesn't get any better than this.
Mr. Cavadas.
Thank you, Madam Chief Justice, and may it please the Court, my name is Stephen Cavadas, and I represent the state system of higher education in Westchester University, who I'll refer to collectively today, hopefully just as the university, because I know Westchester might not be as helpful given the parties in the case.
Counsel, before you get started, I have a very short attention span. Could you answer the question that I asked your opponent, and I said I was going to reserve it for you, regarding whether or not there was any discovery on the uses and any argument by the university that the monies that were collected under this fee were being used for purposes other than stormwater management?
Yes, there was discovery, and that is a core issue in the case. So the case began on preliminary objections, and the Commonwealth Court had a lot of the same questions that Your Honor, that the court did about what exactly the fund is being used for, and that was the focus of the discovery in the case. And what discovery, and again, what discovery revealed and not...
You don't have to go through it line by line. Well, you can point to the reproduced record where it is, because I didn't see it.
Well, the focus would be the Perrone deposition. That's where we point to in our papers. That's the borough manager, Mr. Perrone's deposition, in the reproduced record at page 1250, beginning at page 1250, where Mr. Perrone was asked about, the representative of the borough was asked about what the projects would be used for, and he described the various projects. The park improvements, that would include pervious paving, tree planting, storm sewer improvements to that park. This is about a mile north of campus. There were other projects like tree planting and street sweeping. So they would plant trees along roadways. They would sweep away leaves and trash that would collect on storm sewers. Planting rain gardens, the collection areas that you see that have big plants in them that are designed to, in times of high rain, collect that water.
Contention that these are not related to stormwater management?
No, the contention here, and this goes to the legal question here. So these are certainly related to stormwater management, and there is no dispute in this case that the projects that are being used are broadly, as Justice Robson pointed out earlier, everything that they're using the fund for is broadly related to the concept of stormwater management. But that's not the legal question here. The legal question is whether there is a fee for service, whether this can be categorized as a fee for service or whether it's something else.
Why is it any different from the trash removal and sewer tap scenarios I asked your opposing counsel about?
It is very different from a trash removal because of the projects that are being paid for. So I think we separate, the borough's stormwater system has existed for 100 years, over 100 years. And it is if the charge were to convey water, if this were simply a user fee, as was posited, to convey water, that's not what this fund is being used for.
Well, they can't meter it, so how could it be? How could it be limited to that since it can't be metered?
That is certainly a problem. It can't be metered, it can't be measured in that way, but that's also not what the fund is paying for. It's not paying for the upkeep. The borough manager was asked directly, is there any intention over the next, I believe, decade to use this money to build or even maintain the actual piping system? And he said no. Instead, this money is being used for these other projects. These other projects are they are for a general environmental benefit. And as my friend pointed out.
I explored this with the borough's council. That's really how you defined the system. If you define the system purely by the pipes and the drains, then your fee should be appropriately used to maintain the pipes and the drains, which is what you use. But if you define stormwater system more broadly to include everything that the borough does to manage what goes into the drains and the pipes, to alleviate what goes into those discharge sources, then you have an obligation to pay for a portion of the cost of the entire system, including those portions of the system that ameliorate discharge into the pipes.
What Your Honor is describing is a classic tax, or that would be true of an average property owner, of your average private property.
Every private property owner of developed property is paying this.
That's exactly right. The core legal issue in the case is whether this is a tax or whether it's a fee for service, because what Your Honor just described is why we have tax, or at the very least a regulatory fee. And this is not, the borough has not argued that this is a regulatory fee, because they know that they don't have the authority, because we're dealing with a Commonwealth entity. They cannot impose a regulatory fee on the Commonwealth entity. And in fact, this is the key distinction. My friend brought up the DeKalb County case versus the Norfolk Southern case. The key distinction between those two cases is DeKalb County involved a county who was trying to impose a fee on the United States. There was no regulatory authority in that case, so it had to be a fee for service, as this court has previously categorized it, a quasi-contract arrangement. So the state only has to pay when we're talking about a quasi-contract arrangement, like Justice Wecht, trash pickup. However, and in DeKalb County, what the court said was, because we're talking about a county imposing a charge on the United States of America, it has to be in that fee for service. And it is not that. As opposed to the Norfolk Southern case, the court there was dealing with a private party who didn't have that, and said, it says explicitly in that case that there is regulatory authority here. So it can be imposed as a regulatory fee. The court should put that aside here, because it's not an issue in this case that was briefed. There's no contention that this could be charged as a regulatory fee. The question is usage. And again, I come back to the actual, what the record, as Justice McCaffrey has pointed out, what the record here has actually shown, the uses. So, for example, let's talk about the rain basins. Why do we have those rain basins? Why are they being built? And the reason isn't to manage the stormwater in the sense of to help convey it to a watercourse. The reason is because it provides an environmental benefit.
Well, the reason is because it's going to reduce the amount of money that goes into the pipe, reduce the amount of stormwater that goes into the pipes.
It reduces the amount of that doesn't affect the pipes themselves. The reason
sure it does. It makes the pipes last longer. Less water flowing through, less deterioration.
There's certainly nothing in the record about that's the reason for the deterioration of pipes. The issue is the deterioration of the end watercourse. So they want to have less water with less pollutants and less speed in that receiving watercourse. So,
with respect to, I'm not, I mean, I guess I'm not viewing this perhaps through the proper lens, but why is it not a discrete benefit rather than one to be spread across all taxpayers for you to be assessed based on the amount of your impervious area, and similar landowners in the borough to be assessed based on the amount of their impervious area, as opposed to taxpayers who have no impervious area?
Because we're the Commonwealth, and because that's the issue here, is whether this should be imposed on the Commonwealth. What Your Honor just described would be the same argument as to why the Commonwealth should have to pay property tax to fund schools. Why should a university, a state university, a state building be exempt from property tax for paying for schools? Why should a courthouse be exempt from property tax in order to pay for schools? And the reason is because the court has well developed the concept of immunity.
But is it tied to the alteration of the natural environment that you've done?
Well, property tax is tied to the value of the property, so there's the value of the property. And it's similar in the respect that we assess a property tax in order to pay for schools. And we assess that property tax equally on, regardless, I dropped my kids off at Philadelphia Public Schools this morning, and I get assessed the same property tax as others. So there's no question that I derive an individual benefit. I send my kids to Philadelphia Public Schools. I derive a personal benefit. That's not the question. The question is why this system exists in the first place. And the reason that we fund schools through property taxes is because everybody benefits from good public schools. Whether you have children, had children, don't have children, everybody benefits from it.
What is the test that you want this court to use to make the determination of whether the projects that are being funded by the monies paid toward the storm system have a close enough nexus to the operation of the storm system to be considered, versus what I think you're describing is those projects that have some attenuated nexus but are more in the range of a environmental good thing to do for all the neighbors of the community?
Are you to follow up on that, are you suggesting that we apply the three-part framework from San Juan Cellular?
I certainly, I think that's part of it, but I think there's an initial test here, and I think it's right there in the name, fee for service, a three-part test. Number one, there's a fee, which is not challenged here. There's a charge of some kind. Number two, that there is a service, that there's an individual, discrete private service rendered. And number three, that the charge is related to the service that's being provided. And as I think, let me start on that last part as to why I think the borough's argument fails here. As my friend began his argument by saying, they developed this multiplier. This particular ordinance was developed as multiplier using reverse engineering, looking back on what future projects they wanted to fund. So it's not, the fund was not designed to improve or provide more service, more water, or to build a system of conveying water to a waterway. It was designed to provide greater environmental benefits, infrastructure developments along those, and environmental benefits along the way. And in fact, if it had been designed the other way, if it was, well, we want you to pay, we think property owners should pay, based on impervious service, for the construction of a storm sewer system. What we walk into is the exact situation in the Southwest Delaware County case, where this court held about 80 years ago that a front foot assessment for the construction of a sanitary sewer system was a tax, could not be imposed on a public entity. So either way that they frame it, they walk right into the immunity problem. And again, the issue, the immunity issue here is why this is different than the average property owner. We're not standing here as the average property owner. And what makes us different is because the Commonwealth has other ways to fund these things.
But what makes this different than a gray water? What makes it different from a gray water system or a public water system? Why is stormwater different in kind from a municipal sewer system and a municipal water system?
First of all, those can be metered, and they are. I have a meter at my house to measure the water that comes in.
That argument fails because then you say you can't. That argument doesn't help me because then you're basically saying metering is the rule, which you agree can't be metered. And you say because it can't be metered, they can't collect a fee for the service.
Because it can't be metered, what can't be metered here is the benefit.
Structurally, let's get the metering thing. Structurally, and the way municipalities run water and sewer systems, how is the way the municipality here runs their stormwater system different that makes those fine in terms of fees, but this one bad? Is it just metering?
Because for example, water. There's an individualized benefit to water that I receive at my house. There's a quasi-contract arrangement there. When I open up the spigot of my house to bring in water, I agree to pay for that water in the amount that I use.
You also agree to pay a charge regardless of how much water you draw. Most water systems have a flat fee just to have the system available to you. Same thing for sewer.
Again, and I think a lot of these things you can look. There are always collective benefits and individual benefits to everything.
Correct.
So, but we've got to put these into buckets, or else there's no line at all. So, certainly, as I mentioned, there's individual benefits to a property tax that I get, but that doesn't make it in.
Are you saying you derive no individual benefit from being able to access the stormwater system for the borough?
Absolutely not. There are individual benefits, but on the whole, the system is designed for the collective good. It's designed for general environmental benefit.
How is that different from a public water or public sewer system?
Because at its core, when I drop water, I'm bringing in water for my personal use. I decide how much water there is. I agree to pay for that water. I do pay for that water at the end of the month.
When you tapped into the borough system, you agreed to use the borough system for discharging your stormwater for purposes of your permit. You could have chosen not to. You have completely control over doing other impervious surface modifications to reduce your fee, but you are choosing to access and have chosen to access the borough system, which is not unlike choosing to tap into the public water system or the public sewer system.
First, again, I don't believe that that's what this fee is charging for. It's not charging a user fee for use. It's charging a fee to pay for environmental improvements along that system. But additionally,
but there are environmental improvements to sewage systems. There are environmental improvements to water systems. You haven't yet given me any distinction between treating stormwater differently from gray water and public water.
Because stormwater, when I bring in public water, I'm charged for it and I'm charged based on a contract basis. I can turn my spigot off. I can get water from a different source. I can get well water. There are voluntary choices that go in. Here we're talking about rain. We're talking about something that happens that falls on the surface and that travels and collects, and we have a collective, rain is a collective problem, and managing rainwater is a collective problem. It's a societal, it's more of a governmental function.
I understand, but your client chose to deal with your water problem by tapping in to the borough system. You chose that. You could have done something different. Do they have an obligation to let you tie into that system?
No, that we could not have chosen anything different because rain falls and inevitably leaves. It inevitably travels.
You have your own system, too.
That's right.
That distinguishes the two. What's the discrete benefits?
So and thank you, Justice Weck, that was my next point, which is, I think what Justice Brobson, you're referencing is the MS4 here. That's not what's being charged for. Because if it was, the university would be treated differently than everybody else. Because we're the only entity, I believe, in the borough that has its own MS4. So if it were true that this was a fee for service, that we're going to charge for relying on us in the MS4, that's not the way this is structured. That's not what this is. Whether or not it could be designed that way is a wholly separate question that would have to be done and then litigated separately. But that's not what this is. This is not being charged. This is not a connection charge for an MS4. Because if it were, only the university would be paying it.
What I think you're saying, if I understand your argument, and I think you're making it very well, is unlike a water and a sewer system, this system doesn't exist specifically for you. You are taking advantage of it but it's not a system you don't believe it's a system you tap into. You don't have any kind of contract with them for them to provide it to you or not. It's something they do to manage stormwater within the borough, and everybody has a right to use that borough stormwater system without being charged.
That's exactly right, Your Honor. Why do I use water? For my own personal benefit. But why does this system exist to channel and clean and slow down the water? To prevent erosion, to provide cleaner water, to provide more general environmental benefits. That's what makes this different than the water line coming into my house, where I use it for my own personal benefit. If I go on vacation, I can turn it away and I turn it off and I don't pay for it. Here, if we have a drought, we're still paying for it because there's still improvements that have to be made because really at its core, this is an infrastructure project.
You've both made very persuasive arguments. Are there any other questions at this time? All right, I'd ask you to sum up or say goodbye.
With that, Your Honor, we would just ask that this court affirm the decision of the Commonwealth Court.
All right, thank you.
Thank you.
Or not.
Good job.
Mr. Minner, would you call the next case?
Yeah, no, I'm going to have more coffee. Yeah, I'll go with you, though.
Oh.
I have to go to the bathroom.
Oh, good. Oh, you? She's, oh, I said hello. Who? I know, I waved to them this morning. They were drinking coffee, and I said to put their coffee cups down.
All right. In this case, the claimant in this workers' compensation matter was injured in the scope of her employment, resulting in the amputation of her forearm. While it was undisputed that the claimant was entitled to specific loss benefits under the Workers' Compensation Act, the parties disagreed as to which provision of the Act sets forth the proper rate for calculating those benefits. Finding itself bound by the Commonwealth Court's 1980 decision in Walton versus Cooper, which held that the General Assembly intended to treat total disability benefits and specific loss benefits identically, the workers' compensation judge applied the schedule of compensation for total disability benefits in Section 306A of the Act. The Commonwealth Court agreed in a divided decision, opining that stare decisis required it to follow the prior decision in Walton. The dissenting opinion found that under the statute's plain language, the rate set forth in Section 306C applied to calculate the claimant's specific loss benefits, and Walton, which held to the contrary, was wrongly decided. We granted allowance of appeal to determine which provision in the Act sets forth the proper rate to calculate the claimant's specific loss benefits. Please proceed.
Madam Chief Justice, Justices, may it please the Court, my name is Joseph Prim. I represent Jennifer Jackiw. My co-counsel, George Beatty, is present as well. So this matter really involves a question of the separation of powers in our governmental system. The legislature writes the statutes, the judiciary takes the facts and applies the law to those facts to make determinations. And if the statute is unclear, then it will interpret the language of the statute to try to understand what the legislative intent is. In 1980, as Chief Justice indicated, a three-judge panel of the Commonwealth Court determined that they needed to rewrite the actual language of the statute in order to achieve what they believed was the legislative intent. This was not something that was argued to them. And there's nothing in either the briefs or the decision which would show that they investigated the legislative intent. So the Workers' Compensation Act is a complex, voluminous act, but there are 4 basic schedules of benefits. There's benefits for medical benefits under Section 306F. There's fatal claim benefits under Section 307, disability benefits under Section 306A, and schedule-specific loss benefits under Section 306C. Those benefits, Section 306C, is a schedule of losses for individuals who suffer an amputation, lose a body part, a permanent loss of a body part, as occurred here. Each of those separate sections of the Act dealing with separate and distinct benefit patterns has their own methods of determining the benefits to which each individual is entitled. Fatal benefits are treated differently than disability benefits, which are treated differently than scheduled benefits. So Section 306C has an average benefit, 2/3 of the wages of an injured worker, a maximum benefit, the statewide average weekly wage, and a minimum benefit, which is 50%, clearly stated, 50% of the statewide average weekly wage is the minimum benefit that a low-wage owner will get for the loss of a body part, when they lose an arm, when a leg is cut off. Please. That refers to the amount of total disability. It follows immediately after it says, for total disability, as calculated under Section 306A. It clearly states that the minimum would be 50% of the statewide average weekly wage. It doesn't refer back to that 50%. If it did, it would be a total contradiction. You would have to eliminate that. It refers immediately after that. And to make it even clearer, the next sentence, the next paragraph begins as to what a healing period is. So disability is different than a loss of a body part, especially when you're dealing with low-wage earners, or typically those just getting involved in the labor market. Individuals that are usually young people in entry-level positions. They've lost that arm for the rest of their lives. So they were treated differently than those that suffer disability. Walton was wrongly decided, and as the dissent stated there, it should be set aside. It should never have been considered in the first place. It should be calculated as the legislature states it there. For low-wage earners, if they lose a body part, if they have an arm lost, the minimum that they get is 50% of the statewide average weekly wage. If you look back...
Counsel,
sure.
I'm not sure. Justice Dougherty asked you the question that I have in this case. What does as provided in subsection A of this section mean?
What it means is how total disability is calculated as under Section 306A.
It doesn't reference total disability. It specifically references specific loss compensation. Compensation under paragraphs 1 through 24 shall not be more than the maximum compensation payable, nor less than 50% of the maximum compensation payable per week for total disability. But you would have us stop there.
No. What it goes on to say, for total disability as provided in subsection A. In other words, you calculate what total disability is under Section 306A. It doesn't say...
Okay, so I've calculated total disability under 306A,
but I come up with, but then how do I apply this not less than 50%? Because that's not in A.
The minimum compensation payable for loss of a body part for an amputation is 50% of the statewide average weekly wage. The statewide average weekly wage for disability is calculated under Section 306A, the statewide
Correct.
average weekly wage.
Right.
And then you take 50% of that.
Yeah, but why do you have to go back to A? What's the purpose? You could do that if it didn't even have any reference to A. What's the purpose of the reference to A?
It would have it has a redundancy in and of itself in referencing 306A here as saying total disability is calculated in section.
Well, I think that's the redundancy is the ambiguity. It seems to me.
To show the legislative intent, to clarify the legislative intent, you understand the next paragraph that deals with the healing period. And they specifically state in dealing with the healing period, you pay the amount for disability. And so what happens when you have an arm cut off, you have a stump. That stump has to heal. And what the legislature has done is given a period of time to allow that to heal before you get paid for the specific loss. And it says here, that's calculated, the benefit that you get is calculated under Section 306A, so that for that healing period, for your disability, you get minimum 90%. When Walton was decided...
Well, you get the lesser, right? Under A, you get the lesser of...
You get the lesser.
50% or 90%.
And that's for disability. So conceive what's happening when you have a low wage earner, usually someone starting out, and they suffer a disability. Theoretically, they'll recover from the disability. If they don't, there's whole sections under Section 306A as to how you deal with it, whether you have vocational placement, whether you have an IRE, whether you have return to partial disability. You lost the body part, you've lost it forever. And if you're a low wage earner, you're going to have that problem the rest of your life. So that's why it's treated differently.
I'm not disagreeing. Look, I understand the policy argument that when somebody loses a limb, we should pay them more than, I understand that. I'm asking whether that's what the General Assembly said. And I'm trying to reach a construction that does not render any language in C superfluous. And it seems like your construction, which is definitely more favorable to the worker, I get it, would render some language superfluous. And maybe we have to. Maybe we have to render some language superfluous. I don't know, but I still don't understand. I don't understand the reference back to A. It seems completely unnecessary for purpose, not with regard to healing period, but it seems completely unnecessary for us to reach your construction.
The way the statute is written at the present time, I believe that's true. Historically, there have been changes in the statute, and that language may have clarified things back before the 1975 amendments to the Act, where they changed the benefit rate. The maximum benefit rate was 2/3 of the statewide average weekly wage. Right. And then it became the statewide average weekly wage in order to increase the benefits throughout. And there's a long historical basis for that, including the fact that there was a national movement in order to increase benefits statewide for injured workers because the federal government was challenging the different states. And they said, we're going to take over the whole workers' compensation system unless the states get things together. And Pennsylvania responded, as did many of the other states, by increasing the benefits for the injured workers. And that increased the benefit rate from 2/3 of the state average weekly wage to the actual statewide average weekly wage. Later, they decreased the minimum for disabled workers because There was a time when workers were getting more in workers' compensation benefits than they would be if they're working. And the insurance industry and employers looked at that and said, there's no incentive for people to get back to work because they're making more sitting at home collecting benefits. So the legislature changed it and reduced that from a third of the statewide average weekly wage of the minimum to 90%. That doesn't apply at all to people that are suffer a specific loss. They get paid for the loss of that limb.
And they typically don't get wage loss benefits.
They don't get wage loss benefits except
unless they opt for it.
They can't opt for it if they've lost that body part. That's their only remedy. There are exceptions. If you lose 2 body parts, you can opt for if you lose an arm and a leg, you can opt for total disability. But that's obviously
well, you're presumed to be you're presumed to be totally disabled. That's a presumption. If you lose one arm,
option, but you have a presumption of total disability.
If you lose one arm, you are not presumed to be totally disabled.
Correct.
You could, and you could proceed either to get partial disability benefits or take your specific loss benefit, but you can't get both.
You don't have a choice. You get the specific loss benefits. You don't get disability benefits. Your only option under the statute, if you have lost a limb, a thumb, a finger.
But are you saying that this is a scrivener's error?
No, I think it's a residual phrase that's in there for explaining what the statewide average wage for total disability is that was left in there when the statute was amended time and time again. It explains what maximum disability is, what the
so you would read it as shall not be more than the maximum compensation payable as provided in subsection A, nor less than 50% of the maximum compensation payable for week for total disability.
Absolutely.
You would move it.
I would put it right here. It says, it shall not be nor less than 50% of the maximum compensation payable per week for total disability as provided. The maximum compensation per week for total disability is provided in subsection A.
Which is the statewide average weekly
wage.
Is
the statewide average wage. Yes, exactly. So it's clear that the legislature intended these people to be treated differently. They recognize the fact that if you suffer a specific loss, that is going to have an effect upon your ability to earn wages for the rest of your life, and the individuals involved are the entry-level people that are just getting involved in the labor market, and they have to be treated differently than those that are suffering a disability.
Okay, I think we understand your argument. Are there any other questions? Thank you, sir.
Thank you.
Let's hear from Mr. Pongrace.
May it please the court, Paul Pongrace on behalf of the Aplt Soft Pretzel franchise. The key to this argument, I believe, is if you're looking at Walton, how they interpreted the amendments from the legislature. I won't go into detail. The Walton court already does that, but there is one issue that I want to highlight that I don't think the Walton court highlights, and the dissent in this Commonwealth court case also mentions it but brushes over it, and that is there was prescription language in the original act. Paragraph C ended with, but in no event more than, in no event more than the employee's average weekly wage. So they specifically had in the act a sentence that says you can't get more benefits than what you were earning. That was taken out by the legislature. And I believe that when you harmonize, as the Commonwealth Court said, paragraph A with paragraph C, you don't need the prescription language because you don't ever get to it. You use the 90% floor in paragraph A, which means you don't need to say the employee does not need to, does not get benefits more than what they were earning.
Why don't we just do what the legislature told us rather than what Walton told us? Why wouldn't we just apply the plain language instead of going through all this ledger domain about figuring out what we think their intent might have been?
Well, Your Honor, if you read paragraph C literally, it provides, in this case, an absurd result, which ends in a windfall. This particular injured worker would end up with significantly more benefits than what she had been earning in gross wage.
She'd probably like to have her gross wages back and have her arm back.
I would not disagree with you, and I know that part of the argument is that an amputee should be treated differently. The Act does treat an amputee differently. That's why there is Section A and Section C. Well, specific losses.
That's the point, that you've conceded, as you must, that the legislature set out two different paradigms here.
Yes.
What Walton did was ignore that.
Oh, I don't think they did. What Walton did was eliminate the as in this case, the result where the benefits far exceed the gross wage that was being earned.
But that assumes that you're assuming the General Assembly's intent in giving specific loss benefits is the same intent in providing disability benefits. Disability is defined under the workers' compensation law as wage loss. And you're assuming that the General Assembly meant in compensating for specific loss, they meant to be compensating for wage loss and not something else. That's an assumption you're making.
Well, specific loss, I believe, if I can use an extreme example, if you have a worker who, with more fortitude than I would ever have, if they lose a finger, they go to the hospital and the next day they go back to work and they have no wage loss. Well, the Act says that's still a work-related injury and they deserve to be compensated. That's where specific loss comes into. Specific loss has nothing to do with wage loss.
I agree. So why are you so strident in your belief that because that somehow, some way, the specific loss has to match or bear relation to the disability payment?
Well, I think I can answer that, Your Honor, by the term being used, grievous injury. And I believe the dissent in the Commonwealth Court pointed to and hung their hat on the fact that an amputation is a grievous injury. But the Act does not define grievous injury and doesn't take into account grievous injury. And there's no room for anyone to say that an injured worker is more grievously injured than another.
I mean, you say no room for anybody. The legislature has all the room it wants to differentiate between these classes.
Well, that's correct. And they provide in subsection C how you calculate the defined benefit. And the defined benefit is looking back at A. And again,
I'm sorry to interrupt, but that reminds me, your brief, I'm not sure whether you're saying it's plain language or ambiguity. It seems like, I think you seem to rest on both points at various junctures. Which do you think it is? Plain language? What resolves this case? Plain language or ambiguity? There's not a third option to say it's Walton. I mean, that doesn't answer for us. Ambiguity or plain language? What do you think?
Well, if you read the plain language, I think there is an ambiguity between A and C.
Well, if there's ambiguity, then don't we have to resolve it in favor of the claimant under the humanitarian purpose jurisprudence?
Well, first, I don't think we're left without guidance. I think the legislative intent is important in determining how you work A and C together and harmonize them. As far as the humanitarian nature of the act, in this case, I think the appellee wants a bigger safety net. They want more benefits than what she had been earning. The floor, the safety net in this act, the humanitarian nature of the act, is the 90% floor. That's the remedial.
That's for disability.
Correct.
I'll ask you the same question, a similar question. How do I get to your result without rendering the 50% average, statewide weekly average language superfluous in C? C says not less than 50% of the maximum compensation payable, which is the average statewide weekly wage. How do I get to your result without rendering that language superfluous?
I don't believe it's superfluous until you get to a low-income amputee.
Well, then it's superfluous.
Well, not if you look at the legislative intent when they harmonized A and C.
Who's they that harmonized A and C and legislative intent? Legislative intent starts with the statutory language. So we are supposed to assume that all the provisions are effective and can operate. Mm-hmm. And what you're saying is, I think in response to my question is, the language becomes ambiguous when you deal with a low-income worker. That's a problem, right?
Well, the Act doesn't allow for preferential treatment when calculating specific loss benefits, even if it means, as the Commonwealth Court said here, if it means lower benefits for the injured worker.
But I would just want to make sure I understand what you're saying is the language is superfluous for some claimants but not all claimants, and therefore we should not apply the language here.
No, I believe once the wage is low enough that the benefits exceed the average weekly wage, you look to A and use the 90% floor. That's the remedial calculation.
Okay, we understand your argument. Are there any other questions? Thank you both. Did you want to conclude, or are you good?
No, I'm fine. Thank you.
All right.
Very much.
Thank you both very much. Mr. Minner, the court will take a 1-hour recess for lunch. Well, we're thinning out the crowd. Good afternoon, everyone.
Good afternoon.
In this certified question from the United States Court of Appeals for the Third Circuit, we are asked to determine whether a 1908 tax sale of an unceded parcel of land which had been divided into a surface and subsurface estate, each with separate owners, constituted a quote-unquote title wash, thus divesting the subsurface owner of his ownership interest and giving the purchaser ownership of both the surface and the subsurface estate. Of note, the property at issue was sold by Bradford County because the surface owner failed to pay taxes on the surface estate. However, the property was sold to an agent of the defaulting surface owner. So, you'll enlighten us as to all the issues.
Thank you. Madam Chief Justice, and may it please the Court, my name is Michael Scorinci. I am a Senior Deputy Attorney General with the Pennsylvania Office of Attorney General. I'm here representing Appellant, the Pennsylvania Game Commission, on this certified appeal. Your Honors, this Court should answer yes to the certified question. The 1908 tax sale of the Haynes warrant resulted in a title wash. This Court already answered the certified question in Herder Spring. There, the unanimous Court, in what you, Madam Chief Justice, called a thorough and scholarly opinion, reaffirmed in 2016 what it had said for 200 years. Unceded landowners did not owe a duty to the state to pay taxes. The duty was on the land. Because of the federal district court's errors in reading Pennsylvania law, the Game Commission is here asking this court to reaffirm its precedent. The Proctors, however, want you to upend 200 years of precedent and in the process create chaos for landowners. Beginning with Herder Spring. In Herder Spring, this court reverted back to Powell, which you decided 120 years earlier in 1896. And what you said in Herder Spring is that the Powell court explained the duty, or lack thereof, of landowners to pay taxes. And then again, later on in that opinion, tax on unceded land was the liability of the land rather than the owners. And then in Powell, you said, the taxes under which the sale was made in this case were on unceded lands, and there was no personal responsibility on the owner thereof. The land alone was liable. And then again, later in that opinion, neither owner is under any obligation to the state to pay. Now the Proctors say, Powell and Herder Spring are different because the tax sale purchaser did not own the land when it was assessed for taxes. But that factual distinction is not legally significant because, as you've said many times, ownership is immaterial. In fact, 40 years before Powell, in 1856 in Cox versus Gibson, as even the district court recognized here, the taxes were at least partially assessed against the land while the tax sale purchaser owned the property, and you still held that that was a title wash. As I said, ownership was so immaterial that it was often the case, again, as you recounted in Herder Spring, that often the county commissioners did not even know who owned the land. The land was assessed in the name of the warranty owner. The warranty owner was the person who first received the land from the Commonwealth. And then after Powell, 6 years after Powell in 1902, we see the Superior Court in a case that was authored by former Governor James Beaver, and his name's important for later reasons that I'll discuss. That case, Fink versus Miller, the appellants in that case raised the same exact arguments as the Proctors are raising here, that it mattered who owned the land when the taxes were assessed. And the Superior Court there said, no, it doesn't matter. And then we see authorities over the next 120 years saying the same thing, that it does not matter who owns the land, that a landowner could even purposely default on the taxes and still acquire both the surface and subsurface in a title wash. We see that with the title examiner opinion. I know that Proctors like to cite the title examiner opinion, but he recognized that there was, quote, a widespread belief, unquote, that a person could purposely default and acquire the land, both surface and subsurface, at a tax sale.
Suggesting that the legislature would impose tax on property while not imposing a corresponding duty on anyone to pay the tax. Isn't that a little hard to believe?
As I said in my brief, this was a legal fiction that the law created to address certain problems that the legislature was having in collecting taxes from these lands. These lands were some of the most rugged in the Commonwealth at the time. These owners were not registered with the county commissioners. They were often living far off on the coast. So the law created this sort of legal fiction so that the courts could acquire jurisdiction over these owners who were living far away through in rem proceedings. Also, the legislature wanted to encourage people to have their land assessed so they could collect tax. And then once land is being assessed, of course, the owner is going to want to make a productive use of the property. So there were legitimate reasons why the legislature decided to go this route. And as I was saying before, it's after the title examiner opinion, we have a federal district court in 1956, Sagamore versus Proctor, who, after reading Pennsylvania law, commented that owner of unceded land may purchase the same as an entire stranger to the title, and then recognized that the decisions are, quote, many and uniform, that there is no personal obligation whatsoever on the part of any individual owner to pay taxes on land assessed as unceded.
Counsel, can I ask you a question, a factual question, before you go on and keep telling? It's Third Circuit Senate here because apparently it isn't clear enough for them to decide what Pennsylvania law is. But isn't in this record, don't we have a situation where the taxing body was aware that the subsurface rights were severed and was aware of who owned the subsurface rights and the surface rights?
Well, I don't think they were aware who owned the surface and subsurface. Now, the district court did make a factual finding that CPLC had reported. We challenged that factual finding in the Third Circuit, but that fact is not actually dispositive. The dispositive fact is what was assessed. And we know that this land was assessed in its entirety, meaning...
I understand that. I'm just saying, though, but you know, all the reasons for the Herder Spring Powell idea that you gave may not be here. The county was put on notice. The taxing body was put on notice of, I mean, I don't know if they filed a certification or a recording or something like that, but there was a notification of severance and who owned which estates prior to this tax being issued.
So let me just clarify a couple things. The factual finding that the court made was that there was reporting. Our position is that reporting was based on the fact that CPLC paid the taxes. But again, that's not...
There wasn't a recording of that happened at the time the subsurface rights were separated? There was a notification given to the county? There's
no recording in the record. All that it was is that CPLC paid the taxes on the property. And from that, the court made the finding that, therefore, that it should have been assessed separately and unseparately. But it was not. It was assessed in its entirety. And we know that because, as you explained in
Should it have been assessed, so should it have been assessed separately?
Well, so if it should have been assessed separately, that's what we say is irregularity. It's something that had to be challenged within 2 years of the tax sale. It wasn't. You made this point in Herder Spring, in other cases like Williston versus Colquette. That would be an irregularity. It's not something you can raise 120 years later. It's not a jurisdictional defect.
Well, but what happens if, and this will be my last factual question.
Okay.
What happens if after the supposed title wash, the entity who acquired full ownership by way of the title wash continues in deed after deed after deed to recognize the subsurface separation and subsurface separate estate?
So it depends what would say in the clause. Well, let me put it this way. Once the title's been washed, that interest has been extinguished unless the prior owner takes certain actions like redeeming within 2 years or challenging an irregularity within 2 years. If it said something like, if the deed said something like it's subject to, that's not enough to resurrect an extinguished an interest that was extinguished by the title wash.
Why not?
Because the law says it's not. Subject to is just like a breach of warranty
claim. It's a breach of warranty provision, protects you against, I'm not going to be sued because I put you on notice that there might be something out there. You have to contrast that with an exception and reservation clause, where I grant to you, Justice Brobson, I'm going to grant to you the surface, but I'm going to accept and reserve unto myself the subsurface. In that sense, that wouldn't pass the subsurface. But we don't have that here. This is not a deed case. This is.
So what was the purpose in this case of the deeds language that, as I think you agree it was here, everybody seemed to be operating under the impression that the subsurface right survived the alleged title wash.
So the deed language had the subject to language. It was just a breach of warranty provision, a way to prevent being sued in the future, but it was not a provision that resurrected something that was extinguished. And getting back to what you just commented, that everybody knew at the time, everybody did know at the time what this was. It was a title wash. It wasn't a redemption. I know the title examiner expressed what would be a minority opinion at the time, but he recognized that this was a widespread belief that this had been a title wash, and this was the kind of thing that happened on a regular basis. If you look at a Superior Court case from 2019, Kettagas, which was decided after Herta Spring, it's the same exact facts. CPLC owned in 1908. Macaulay Jr. bought at the tax sale. He sold it back to CPLC 2 years after the redemption period had passed. And the Superior Court rejected all these arguments about agency and said that it resulted in a title wash. So the law is really on our side, Your Honor.
See if I have this on. Let me ask you about Powell, because I think Powell is the case that is sort of the genesis of this rule that we're talking about. Is that correct?
I think, well, I want to be clear. The rule itself, this idea that you can't neglect you can't acquire a better title through your own neglect, I think that predates Powell by many years. It's like black letter law, but we've used it shorthand to mean the rule of Powell, just to express that concept.
Well, let me ask it a little differently. Don't these cases stand for the proposition that when you have unceded land, a taxing body in a attempt to collect those taxes by way of a tax sale can look to the property for the collection of the tax, as opposed to looking to the personal assets of the owner.
Yeah, this is correct.
But that's different. That doesn't say that the owner does not have a duty to pay taxes.
Except you've said it over and over again for 120 years, and I think.
I'm questioning that proposition. I mean, because frankly, the notion that a property owner has no duty to pay taxes is nonsensical. I mean, a property owner may not have a personal responsibility from personal assets to pay the taxes at a tax sale, but to turn that into there is no duty to pay taxes, I think is a gigantic step. I mean, the problem with Herta Springs is the addition of one clause in the middle of a paragraph that says duty to pay taxes, comma, if any, comma. That's the misplaced statement in Herta Springs, in my opinion. I'm just looking for the notion. Your question about, well, how do you get jurisdiction if you don't actually know who the property owner is? I mean, you do that in the way it was done. You bring the action, you bring a collection effort, and at the tax sale, you sell the property to pay the tax obligation of the owner. You don't look to the owner to pay from his or her personal assets, his in this time frame, because women actually didn't own a lot of property in this point in time. But I'm a little bit uncomfortable. In Lancey, in the Powell case, he wasn't the property owner at the time the assessment of the
right.
Tax
I pointed
assessment.
that out.
He had no duty. Period. He had no duty. So when you say that the owner had no duty, it's because he didn't own the property at that time.
Well, I have several responses to that, to Your Honor. First, I'd say when we talk about the word duty, if we just want to start with that, You used it in a straightforward way. We all know what duty means. It's a legal obligation. And we're supposed to read legal opinions as straightforward expressions of denotation, meaning we take them literally unless there's some kind of contrary indication in the opinion. And there's not. You said there's no duty in a variety of different ways. No personal obligation, no personal responsibility. The land alone is liable. If you look at Neal versus Lacey, I think is a very important opinion, because there you have a court holding that there could not be, an unceded landowner could not recover in contribution if he paid the entirety of the taxes. And the rationale that underpinned that case was that there was no duty on the landowner. And I think this gets into some of the many holes that we see in the Proctor's argument in terms of, I've touched already on ownership is immaterial. I've talked about contribution. If the personal duty, I know you said it was just in the middle of an opinion, the idea about that duty. If any, right. But actually, you mentioned it twice in that opinion, and it was pivotal to both parts of the opinion. That opinion dealt with the extent of the assessment and the legal consequences of the sale in 1935, and then constitutional due process. And it was pivotal. It was integral to this court's opinion on constitutional due process that there was no duty. Because if there was a duty, just like for ceded land, then the landowner would have been entitled to personal notice. Now, if you say there's personal duty here, then all those unceded landowners would have been entitled to personal notice, because an in personam action requires personal notice. So that would throw into doubt every unceded land case that's happened in the past 120 years. And of course, notice is a jurisdictional requirement, so that could be challenged even 120 years down the line. And I'd like to just point out a couple other things in terms of the duty argument. Another, I think, problem with their argument is that they recognize that title wash happens in a number of different situations. They talk about how where the property is assessed as a whole and then purchased by purchased by a bona fide purchase, that's the Herders Spring situation. They say that's a title wash. They say where there's adverse claimants to title, where there's a potential cloud on title, and one of them purchase, that's a title wash. And they say even when someone acquires the property after there's been a lien, that person can buy at the tax sale, and it's still a title wash. So the proctors recognize all these different situations where there is a title wash. And so I think, how can there be a duty just some of the time? There has to be a duty all of the time. And I think another problem that they have with their theory, what I would call the quantum theory of title wash, is the idea that it matters. This theory hinges on what Macaulay did after he bought. So if you're familiar with Schrodinger's cat, with that thought experiment where the idea that particles can be in two different states at the same time, depending on, until you observe them, you won't know. That's Schrodinger's cat thought experiment, where the cat could be both dead and alive, depending on, until you open the box. It's the same thing with the title wash. It could have been a title wash if he sold to CPLC, but it's not a title wash if he sold to somebody else. And I think that gets into the problem. What kind of rule of law is that it depends on what someone does after the fact? And how would someone who's examining the title record know if this is a title wash just on the fact that Macaulay Jr. sold to CPLC, unless examining things extrinsic to the title record to figure out who this person was.
And you're saying there's no obligation for the taxing bodies to examine the deeds recorded for the property to determine who has...
Yes, that's... Yeah, you made that very clear in Herders Spring. They have no obligation.
Well, I know. I understand that we made that, but I'm wondering whether whether that law that creates the fiction,
yes,
makes a lot of sense in an era where deeds are recorded the way they were back then and the way they are now.
I mean, it makes the legislature provided different ways for a landowner to protect himself. There's nothing inequitable here, but it was not an obligation on the part of the county commissioners to go searching through the deed records to see who owned the land and how it was transferred. That was up to the landowners. And just to point out some of the ways the question hasn't come up so much, but there was nothing inequitable here. What is inequitable is coming to this court 120 years later and seeking to destroy the title that we gainfully acquired. The proper way for the proctors to protect themselves, there were 6 different ways. They could have paid the taxes on the entirety of the property, just as CPLC had done for those many years when the the proctors were free riders.
Who got the tax notifications during those years?
I don't believe there's tax notifications. The tax notifications were the tax laws. These, everybody, that's what the case law says. Everybody knew that these taxes were due every 2 years. And the tax sales happened on the same second Monday of June every 2 years. That was the notification that the law provided at the time. This was not the time of the internet, you know. Do we know if taxes were assessed to the subsurface? We know absolutely that taxes were not assessed to the subsurface. This was a taxation of the land in its entirety. And the way we know that is because, as you explained in Herder Spring, you look to the treasurer's deed and to the assessment record. There would have to be something that indicates in either the assessment record or the treasurer's deed that this was a sale of only the surface or an assessment of only the surface. It would say something like coal only or gas only or minerals only. And keep in mind, as I pointed out in my brief, from 1890 to 1935, there was never an assessment of a subsurface land in all of Bradford County. And the proctors actually concede that there was never a separate assessment. Their argument in response is that this land did not have, this land lacked accessible value. Now, yes, to pay it in entirety, just like CPLC was paying the entirety. Well, those taxes were on the entirety. They belonged to both to CPLC and to the proctors. Either one could have paid to assure that their land was not sold. But there were many other ways. If they had gone and got a separate assessment, they could, what would have happened with a separate assessment is that if the taxes were not paid on the surface, only the surface would have passed at a tax sale. But they didn't obtain a separate surface. They could have made an arrangement with CPLC and made a contract and say, they had an obligation under one of the acts to come and report their interest and make sure that it was separately assessed. If you did not have it assessed, when you report, there's supposed to be an assessment. But that's true, Your Honor. They found that there was a reporting. However, there was not a separate assessment as a matter of fact and law. And that's something that you can't come to this court 120 years later and say, oh, you should have separately assessed it. No, you have to do that within 2 years. That's very clear in the law. That's an irregularity. You've said that in some of the cases I mentioned before, Herder Spring and Williston versus Colquette.
Well, what more is the property owner supposed to do than to come to the county and say, I own these subsurface rights. I'd like to place my notice on the record that those are my rights. Isn't that then up to the county to take the next step to do the tax assessment?
Yes, again, but it didn't happen here. And what the proctors could have done in addition is that after the property was sold at a tax sale, they had 2 years after that to either redeem or pay the taxes. Pay the taxes, redeem by paying the taxes, or challenge that lack of assessment as an irregularity. There were many ways that they could have protected themselves. They did none of them. And for that reason, they lost their property.
Counsel, what if...
Excuse me?
What if in the 1908 tax sale, let's see, what would have happened if CPLC had gone to the tax sale and paid the taxes?
Then there would have been no tax sale. Because if you pay before...
Would they have acquired the subsurface rights?
Before the tax sale?
No, at the tax sale. They come in and they pay the taxes at the tax sale.
Has the default happened already? I mean, if there's
Yes.
if the default, then yes, they acquire the surface and subsurface.
No, it's a redemption.
If you,
It's a redemption. If you go to the tax sale and you're the record owner and you pay the taxes at tax sale, that's a redemption.
And all you get is what you owned, which is not the subsurface rights. That's because they had a duty to pay those taxes in the first
There's been a default. There's been a default. You buy it. You would acquire a title wash, I believe, Your Honor.
When you can't do a redemption at the sale?
You could do it a redemption, but it would have been so. If there was a redemption, there would have been a stamp on the deed that would have said a redemption. Not.
Yeah,
but this was not a. This.
I'm giving you the hypothetical.
Yes.
Instead of using their agent so that, in their view, a title wash would be effectuated, instead of doing that, the property is put up for tax sale because there's been a default on the taxes, and CPLC goes in and pays the taxes. They don't acquire the subsurface rights in that context, correct?
If there hasn't been a default, yeah. If they're paying the taxes, I think so. Yes. But it would have to be. You would have to have an indication that this was a redemption. And I think the way that occurs is through a stamp on the deed saying that this is a redemption only, not a tax sale.
I think Justice Donohue's,
At their option?
Well, the treasurer would have done that.
I think Justice Donohue's point is, though, is you would agree in a tax sale, even today and even
Yes.
back then, if a property owner showed up at the tax sale, the day of the tax sale, and wrote a check for the unpaid taxes, the tax sale would be called off and it would be a redemption.
You know, I'm thinking of Neal versus Lacey, Your Honor, and I think in that case, they had both parties show up at the sale, and one purchased at the property, and the court made a comment in that case that if it wasn't redeemed within 2 years, it would have constituted a title wash. So I point to Neal versus Lacey.
You're saying that the taxpayer has no ability to pay the taxes.
I think they do. I think it depends on intent there, I guess. I think they do.
I honestly, I'm sort of lost by that analysis. So they decide whether they get a title wash?
I think the treasurer decides that. I think the treasurer decides, Your Honor.
If the treasurer says the current owner gets a title wash, why in the world would the treasurer, why in the world would the past owner and now current owner ever challenge a redemption? Because if they do a redemption, then they lose the most that they got at the tax.
Right. I see your point, Your Honor. I do. And I would go back to Neal versus Lee. I think you can pay at the tax sale and redeem, pay your taxes and then you don't lose your land. I think that's true.
But that's because you have a duty to pay those taxes.
No, Your Honor. You said very clearly many times there's no duty. And as I pointed out, you can't say there's a duty and then say a person isn't entitled to contribution. And you can't say there's a duty and then not provide personal notice. The theory falls apart as soon as you say there's a theory.
The personal notice would allow the taxing authority to look to assets other than the property to collect the taxes. That's what personal notice would get them. You'd get jurisdiction over the person, so that as opposed to looking to the land, you look to the assets of the individual other than the land.
But you said that where there's for ceded land, the law was for personal duty, you had to have personal notice. So I think that's, again.
That's what I just said.
Yes, but for unceded land, it's different.
Your personal duty arises from your, that's looking toward the individual assets of the person other than looking to the land to pay the taxes. Garnish a bank account or something of that nature. That's why you need personal jurisdiction over the owner. Mm-hmm. If you don't have personal jurisdiction over the owner, you in fact have in-rem jurisdiction over the land, and so that's what we say, you look to the land.
I disagree. I'm sorry. I go back to, you still need personal notice if you're going to have an in personam action, and I think that was integral to your opinion in Herta Spring.
And I agree with you. I agree with you. These are in-rem proceedings, which
right.
is why you can only look to the land to satisfy the debt. And that is the history of the law regarding unceded land, as I understand it. I mean, and obviously our cases leave something to be desired, since the Third Circuit is asking us to clarify it in this context. But
Sure. And let me, if I may, Your Honor, maybe I can just talk about a few of the cases that the district court thought was so pivotal in this case, and really my friends, the proctors, haven't really talked about those cases. I just briefly would like to go through them: McCoy versus Michoud, Bresch versus Cox, and City of Philadelphia versus Riddle. All these three cases did not raise a Powell issue, and for that reason, they're not controlling. McCoy versus Michoud had to do with the duty to report, not the duty to pay. Bresch versus Cox had to do with a jurisdictional defect in the sale because the landowner attempted to tender payment well before the sale. And then City of Philadelphia versus Riddle is about adverse possession, where the argument was that the person who failed to pay, his failure to pay constituted abandonment for purposes of counting the 21-year requirement to gain adverse possession. And as far as the Act of 1887, I know that was a big issue that was brought up. The Act of 1887, we have to read that statute in its statutory context, and the context was a 6% interest charge, not changing the law. And I know I mentioned the former governor, James Beaver. He was the one that signed the Act of 1887 into law, so he understood unceded land and what that meant. And as I said at the beginning of this, he decided that case, Fink versus Miller, 15 years later, and he didn't cite to the Act of 1887, and neither did this court in Powell or Heart of Spring. Your Honor, I had a couple more, just two more points, if I may. Yes. So, alternatively, if you do say there's a duty on the part of a landowner to pay, our position is that that duty was owed to the Commonwealth. And therefore, only the Commonwealth can complain about a breach, not the proctors. This is, I would analogize it to tort and contract law. Someone who suffers, someone who's owed a duty, that's the person who gets to sue, not the proctors. And I pointed to Justice Cooley in my brief, who made the same point, that when a tax sale has been made and the state has received its revenue, albeit tardily, but made up with costs and interests, there's no wrong been done to the state. So how can one landowner insist that the other shall discharge a duty to the government for his protection? And we've also relied on the statute of limitations. Our position is that although the proctors say they're really just they're trying to figure out the effect of the sale, what they're in fact challenging is an irregularity in the sale. The Third Circuit actually made this observation in their certification opinion in a point heading. They asked whether Macaulay's status as an agent of the CPLC constituted a jurisdictional defect, and it's not. It's a mere irregularity, and that's something that has to be raised within 2 years after the tax sale, and it wasn't. If there's no more questions, I'll wrap up, Your Honor.
Please.
Okay. If the proctor's brief is any indication, in a moment you'll hear from their attorney a lot about stealing their land and how they are innocent victims. Before this court is a legal question, and that legal question is of the proctor's own making, because the taxes on the Haynes warrant weren't paid, and because the proctors didn't try to redeem the land after the sale, and they didn't attempt to timely challenge the sale. This court is a court of law, and it decides legal questions, and the answer to the Third Circuit's legal question is governed by Powell and Heart of Spring, and not by dicta or digressive statements from legally distinguishable cases, and certainly not by rhetoric. Thank you, Your Honors.
All right, thank you very much. We see why the Third Circuit sent this to us. It's a complicated issue. Mr. Aronchek.
May it please the Court, I'm Mark Aronchek, representing the Trust of the Proctor heirs, and with me is Mr. Weigel. Your Honors, I'm going to sort out all of the misstatements and misstatements of law and, in fact, of fact that my opponent presented to you, and I'm going to answer all of the questions that you asked in due course, if you give me time. PGC is advancing two propositions in this case, two propositions that are unsupported by any case law, and when you just scratch the surface, they make no sense. So let's just start there. First, were owners of unceded land exempted from everyone else's duty in the 19th century to pay their taxes? Decidedly not. And second, was it even true in Pennsylvania, in fact, in anywhere, that someone could acquire a surface estate, not by deed, surface estate, that's what it says, not pay taxes on it, go to a tax sale on the property, and not only get back their property, but have the state processes, the power of the state, take a neighbor's property and give it to them as well. And that makes no sense either. The analytic framework for the Third Circuit's questions is the Powell Rule, not Herder Springs. Herder Springs is a secondary part which I will address, but the Powell Rule is the analytical framework, because that rule says that you cannot profit by your wrongdoing and improve your title or get someone else's property. The difference between the case before you and Herder Springs are two important facts, and I think Justice Donahue put her finger on it earlier. And that is, Herder Springs, you had a bona fide, good faith purchaser at a tax sale, a stranger to a title, who owned no duty to pay the owner's taxes, owed no duty to report the owner's severance. This was a stranger, and that person can go to a tax sale and buy whatever was up at the tax sale. And the second is the landowners in Herder Springs did not report their severance. They violated their duty. In this case, CPLC did report its severance. Here are the key facts that to sort through that really matter in this case. CPLC had a deed which expressly reserved the rights, the subsurface rights, to the Proctor and Hill folks, and all they got were the surface rights. In 1904, they paid their taxes and they had their surface rights. Didn't get anything else. Same in 1905, same in 1906. 1907, they didn't pay.
Counsel, just clarify. You said they paid their taxes.
They paid the taxes on their surface assessment.
So you're saying factually there were separate assessments for surface and subsurface?
What the district court found was that, first of all, it will not matter for my analysis as I go forward for the Powell Rule. But second, the district court said they reported their surface rights. Therefore, we presume that that was the assessment that the assessor's charged with assessing those rights. That's how the statute works. And that there was no value, no assessment, no value. In Herder Springs, in fact, this court, Chief Justice Baer said, if there is no value, there's no assessment. And that is what is in the record of this case. Third Circuit has asked you to look at the record, the findings in this case, not They told you you're not doing fact-finding. You're taking the record as it is proposed to you and as the district court found. Now, the other step I was taking in terms of the facts are that in 1907, they don't pay their taxes on the surface estate. No doubt, as you can read in the cases, because they had taken whatever they needed. The lumber company took whatever they needed at that point in time, and they're either doing a business deal to force a reassessment because it's a triennial assessment, or they just didn't pay their taxes. My opponent is saying suddenly, each year when they pay their taxes, they have only their surface estate, but suddenly they don't pay their taxes, and they go to a tax sale, and they wind up with their surface estate and a reward, a bonus, that the state, the power of the state, takes somebody else's property and gives it to them as well. That's nonsensical. And here's why we know it's nonsensical. And here's why we know that there was a duty. Justice Donahue, Justice Mundy, everyone else who asked, this makes no sense. Of course there was a duty. I want to start with the statutes that create the duty. I like to start with statutes, and then I'll go to the case law. The 1804 statute was an innovation, no doubt. They were having trouble getting unceded landowners who lived elsewhere to pay their taxes. It's a burgeoning state. They need the taxes. New governments, local governments, they want their taxes. So rather than give a break to the unceded landowners who live out somewhere else, make their life easier, they made their lives harder. They said, no more in personam remedy for you, which is what they had for the unceded landowners. We're not going to go chase you. What we're going to do is something harsh. You don't pay those limited taxes, we're going to put an in rem proceeding to take your land. In the 1804 statute, they gave 1 year before that in rem proceeding could start. What is supposed to happen in that 1 year? The land is going to get up and go down to the assessor's office and pay taxes? In that year, and the Bruin case says so, in that year, the owner can come in and pay the taxes and avoid losing their land. They gave them a grace period, a year. In 1806, in the next statute, what happens in the next statute? They say that if you become an owner of unceded land, you have to report who you are, your ownership. Why 2 years later are they saying to people, report your ownership if you don't have a duty to pay the taxes? Why are they wasting their time? In 1815, they hammer it down again in Section 1 and 3 and 4 of that statute. It's all about the owner can come back in and the owner can redeem. The owner. They didn't say the land walks back downtown and redeems. This is all about the owner. Now, the court, I'm going to get to 1887 in a second, and I'm going to show you why we're not talking about elephants and mice. But the court now has 60 years of cases. We recite some of them in our brief. But let's start with Kittanning. This court, unanimously, persons pay taxes, not property. This is so even when the remedy for the recovery of the tax is in rem. The law only takes hold of property as a means of enforcing the duty of the person. This is your words, this court's words. It would be absurd to think otherwise because inanimate things cannot perform duties. And this court said so again in Breisch. In fact, in the, let me get the name of it, the Saukry case, this court said directly, I'm sorry, it's the Strouch case in 1841. This court said directly, a vigilant owner has nothing to fear. All he has to do is pay his taxes, and he's bound to do this upon every principle of equality and justice. That exact sentence was quoted twice by Chief Justice Speier in Herder Springs. To say that Herder Springs says there's no duty when this court quotes that statement from 1841, and it's the same in the Breisch case. The payment of taxes on unceded land is a duty, and a failure to perform it is the fault of the owner. And as I said, Herder Springs says that as well. And it's not a moral duty, as they try to say, because you said in McCoy, in Laird, in Kittanning, that this is a legal duty. You can't take somebody's in rem property without the breach of a legal duty.
I completely follow what you're saying and understand what you're saying, but there seems to be a factual legal dispute between the two parties here. One, whether the taxing authority was on notice of the severance of the estates, and two, whether its assessment was based only on the surface owner's estate, because their theory sort of relies on the idea that if there was a duty, it was a duty owned by everybody.
Okay. So let me try to unsort that out. We're going a little bit over to the second breach of duty. We were talking about duty to pay here, but
but their point, his point is your client had a duty to pay too. If there was a duty to pay, it was a duty to pay by everybody.
There are two separate estates here. They were reported as severed. The subsurface owner has no duty to pay the other guy's taxes. I mean, that's like fundamental.
There seems to be a factual dispute over whether there was actually, whether the assessment here was purely for the severed estate.
You have to, I'll go to Herder. Let's just forget about Powell for a second. Herder says you have a duty to report. If you don't report, you're at risk. You violated your duty. If you're the owner, by the way, just footnote, who doesn't report, that's the Powell rule. You can't go in and get something more than what you failed to report about. So Powell hurts them. But put that aside. If you report, the way the 1806 statute, 1815 statute, the way the case law analyzed it is, the assessor is charged at that point, can only assess on what was reported. The surface owner assessment can only assess on what was reported. That's what the assessor did with CPLC and its predecessor in 04, 5, 6, 7. That's the charge on the assessor. That's the obligation of the assessor. Anything more is a void sale. It's a void assessment. It's like as if it never happened. And in Herder Springs, the chief said, and I keep saying the chief, but he wasn't the chief then, but to me he's always the chief. This court said that you presume that the assessor has acted rightly so, that that's what he did. And that's what the district court finds. The district court finds, yes, there was reporting, and we presume that it was only on the assessment. After all, it was only CPLC paying the taxes each year. They paid the taxes, and they only had a deed for their surface rights before the tax sale.
I think the question is a little bit different, and I thought you might have answered it earlier. The district court found, much as we discussed in Herder Springs, that there was no value attached to the subsurface rights. So there was nothing to assess. That didn't mean there weren't subsurface rights. They just did not have a value attached to it. Do I understand that correctly?
That is true. And that is also the answer. You know, it's not like there was coal everywhere, all over northeast Pennsylvania in all these different counties. And if these were wild lands with no value and no obvious activity on them and no obvious activity nearby. And so it is not surprising that much of the land, from an assessor's point of view, had no value. And if it has no value, that's the end. My opponent makes up these conventions like, well, the assessor still had to give a tax bill that said zero on it. Says who? Where's that come from? What actually happened was, as this court said in Herder Springs, no value, no assessment. Not like you generate some zero tax bill or something. No value, no assessment. And so I will get back if I haven't fully answered your question, Judge Brobson, but I want to go on to the duty, because my opponent is conflating all sorts of law. And the first place he conflates is, well, there are these other cases that say the land is responsible, the land has an obligation, the land has a liability. So it must be that they had this massive fiction that only the land had a duty. No, there's two rows of cases in the 19th century from this court, two, that say duty, 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 legal, 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 and these are some of the ones starting with Katanning that I have cited. There's another set of cases that says the consequence of breaching the duty, what happens when it's breached, is an in rem proceeding. In that proceeding, we don't care about ownership. We know it's a piece of land that's going to be sold because you didn't pay your taxes. And yeah, the land is then responsible. And the two main treatises of the time, these are not random citations, the two main treatises, Cooley on taxation, Black's Law Dictionary, Black on taxation. Both of them say exactly that any kind of colorful language about the land is responsible. They're talking about the consequence of the breach of the duty. These cases harmonize. You have a duty to pay, you don't do it, the land is responsible as a remedy for covering what you should have done. So then I get to the 1887 statute where they talk about elephants and mice, and cats today also. The 1887 statute is they accuse us of reading a statute plain English. Can you believe that? They accuse us of reading a statute the way they should be read, in plain English. But the plain English is that the owner has an obligation to pay the taxes within a year, and if not, it's a 6% interest. The 1887 statute is just picking up 80 years of 19th century law and stating it again. The innovation was a 6% interest for failure to pay, because if you look at the past statutes, there was no interest rate. So and then in 1945, the legislature says it again, before the concept of seated and unseated failed. So what are the implications of the existence of the duty? That's the Herter rule. The Powell rule. That's why this is a Powell analysis case. In Powell, it clearly says that you cannot do wrong and benefit. This is fundamental. This is Cooley said this is such a fundamental rule as to not even require any explanation. And Black said the same. It's universal. It's a universal rule. You cannot profit. What?
They used to be able to get away with that. We
What?
can't do that anymore.
Yeah, well, then I'll explain to you. But
It's so basic. It requires
But I'm going to tell you something interesting, and I suspect it might even be interesting. It'll be interesting to the whole court for sure, but I think for you, Justice Wecht. And that is, let's deconstruct for a second Powell. Let's look at what the Powell court relied on in setting forth the Powell rule. They relied on three sources of law. One, Michigan cases, extremely important, and I will explain why. Two, other states' cases. And three, the Cooley and Black treatises. The Michigan case, why is this important? Here's why it's important. This is kind of a cool fact of legal history. The case that they cite in the Powell case is Blackwood, written by Chief Justice Cooley in Michigan, the Chief Justice who wrote the treatise. And he said, there is a duty on unceded landowners to pay their tax. That's what he said in that case. The second case, which the Chief was part of the panel, the Hirsch case in Michigan, this says that there are these situations, another conflation that I'll get to here, of adverse claimants to the same piece of land, the same title. Two people have a colorable right to the same plot. This is classic title washing. You go and you figure out how to clear the defect on that title. This is not our case. Neither the surface or subsurface owners were claiming each other's property or a defect on their property or anything of the sort. So Cooley says, the Hirsch case says, don't conflate the adverse claimant cases. They're different. And then the third case, and this is the cool part, is Cooley versus Waterman. The Chief is now a plaintiff in the case. What happened? Identical to our case. His neighbor defaulted on a bunch of lots and then claimed Cooley's lot, poor Chief Justice Cooley's lot, as part of his own. And then went to try to redeem it all, to purchase it all at a tax sale. And the court said, plaintiff, Justice Cooley, plaintiff who didn't participate, it says so in the opinion, you didn't lose your property. He can't benefit by defaulting on his lots and go take you, Chief, your neighboring lot. And it is this set of cases that go into the Cooley treatise on taxation. It's only 5 pages long, and you will see it's a duty to pay. The Powell rule doesn't let you take your neighbor's property, and the adverse interest against the same property that two people claim title to, that's different. That's a classic title defect. So I think that's kind of a pretty cool fact. But what they are saying is that Cooley versus Waterman was wrong, that everybody should have known, Chief, you lost your property. They're saying that that applies here today, too. Let me explain to you what is actually happening here in a couple of ways that I know that this court is, you can see in the amicus briefs. Let me explain a couple of things. First of all, they are conflating duty and responsibility, the remedy, conflating them when no case ever conflated them. Two, they're conflating adverse claimants to the same plot with taking, okay, your neighbor's property by power of the state, conflating those when they are unconflated. And in addition, they are trying to conflate mere irregularities that you clear up in 2 years with the effect of a tax sale in Fisk and in Lyman and in Herder Springs itself. This court has said over and over again, when you get to the effect of a tax sale, that could come up any time in the future or no time. Maybe nobody claims a problem. In Herder, it came up 6 years later. In Brannard case, 30 years later. If somebody bothers to come in far in the future and say, that's my property, and it's because of the tax sale, and I want to go over the effect of it, you come in any time. The court sits here to decide, do you have that property or didn't you as a result of that tax sale? They say, well, no, you should have gone in 2 years and said, hey, wait a second, I want everybody to know that the effect of this tax sale is I didn't lose my subsurface rights. Why? In this case here, where we're dealing with sophisticated people, none of them believed at the time in 1908 that the subsurface rights were lost to CPCL. None of them believed that. They knew that Macaulay went in and got a redemption, and they proceeded for the next 10, 12 years where the Proctors had the subsurface rights. They were even leasing out rights to see if there was coal in some of the subsurface property. And in the CPLC transaction, I mean, this part is really a misstatement, and this is when I say, and I don't lightly say that. In the CPLC transaction, the deed that went to CPLC said you got surface rights. It's not a subject to. It says, the deed says, reserving and saving unto Proctor and Hill all the minerals, coal, oil, gas, or petroleum under the surface of any or all of the lands, which includes this warrant. That's not subject to. That's a plain reservation in the deed. And PGC knew it in 1920. They say, well, maybe their title examiner was advancing a minority view. No. Read, it's in the record. He was saying, you don't have the subsurface. And for the next 70 years, until somebody found Marcellus Shale, they all acted in the same way. Now, here is the part that I wanted to get to.
Mr. Aronchik, before you get to that point, I want to make sure I understand. You're purely distinguishing this case on the Powell methodology. In other words, if the agent of CPC did not purchase it, but it was a good faith purchaser for value, you would concede a title wash happened?
I would.
Okay. Thank you.
If there was a good faith purchaser and if the whole warrant was put up for a tax sale. So, chaos. Chicken Little stuff. Things you always hear when they know they're in trouble. Here's the reality. There's about 300 to 350 tracts, parcels, that are CPLC, Macaulay, or in some cases Jones, the general counsel who took over for Macaulay of CPLC. There's about 300, 350 parcels. Collectively, with the three families, the founders of so much industry in Pennsylvania, which I'll address in a second, there's about that number. And for this purposes, they're identical. There's surface rights to CPLC, reservations to the Proctors, tax sales from a Macaulay or a Jones or some agent, then deeds that show that all that CPLC had was surface and the heirs kept the subsurface. You decide this case the way I am suggesting, that there was a duty to pay and the Powell rule applies, those cases all go away. You will never see these title cases again, and it is the largest tranche of dispute that remains involving Marcellus Shale.
Is that related to the point in the Donovan and Reed amicus brief about the uncertainty being priced in?
Well, I'll address that in a slightly different way. I think what you're getting...
I thought you were getting to that when you were
yes.
chaos.
Yeah, well, first of all, there will not be chaos. There will be stability if you decide it our way. If you just stability in reality of what the law is. You decided their way. We got to go back on every one of these and fight. Was there reporting? Was there not reporting? Was there a sale? What happened at the sale? What happened after the sale? All of what the district court dealt with for several years in developing the record. That becomes necessary in almost all the cases. And the notice issue, which they talk about, that's moot also. That goes away because it's not the subsurface owners who were claiming that they should have received some more notice. You don't even get to that issue. The subsurface owners kept their subsurface rights. Here's the meta issue of what's going on, and you get this out of the amicus briefs. You get this out of the amicus briefs. There is a closed loop of people who were paying attention to this issue. They all know who each other is, and they all know where the tracks are. And what happened was there was some clever investors from IDC, it's in the amicus, you can read it, who said, gee, you know, CPLC's in bankruptcy a few years ago. Just buy all these old deeds, let's see what we can make out of them. And came up with this idea that, hey, maybe if we look at this again, the treasurer sales all back then, there were several treasurer sales, passed along subsurface rights. We'll take a flyer. We'll just take a speculation, a flyer. Now, what they went and did was to bring a different case, which is in the record, the IDC case, as between these speculators, these Wall Street types, a few of them, and PGC. And they said, you know, if you have any subsurface rights, and we don't know if you do or you don't, we think you do, that has to be litigated, that's this case. Our rights in bankruptcy trump your rights. So what the fight really is all about here is whether or not some speculators, recent speculators, have the royalty stream, which runs 16 to 22%, depending on negotiating and what's underground, or what they think might be underground, whether they get the royalty or the heirs of these families who invested enormous amounts of money to create a gigantic leather industry when we had virtually no significant industry in Pennsylvania in the early 19th, in the mid-19th century, and then went on to help facilitate a lumber industry where towns are being built and railroads are being laid and houses are being built and jobs are created, and then went on and kept the subsurface rights and allowed for leases to explore, maybe there's coal somewhere, and that created more industry. And now their heirs have these subsurface rights, and voila, there's maybe some Marcellus shale underneath some of these tracks, won't be under all the tracks, some of these tracks, and they want to come to you and say, take it all away. Because the PGC in 1920 is what? Stupid? Different than the PGC in 2020, in 2024? No. This is, and I'll wrap here, because I'll give you a colorful analogy. This is asking you to get into your DeLorean and go back in time and conflate all these areas of law, conflate duty and remedy, conflate irregularity and effect of a tax sale, conflate adverse interests, and you can take your neighbor's property. Ignore the power rule like it didn't exist. Go back in time and change all that law. Get back into your DeLorean, come here today and say, you know, the law really was different. There's a different owner of the subsurface rights. It's not you, the Proctor heirs. Anyway, if there are any other questions, I'd be happy to hear them. There are probably some things I didn't cover.
I don't think there's anything you didn't cover.
All right, well, thank you.
Thank you very much. Thank you both. Next case, Mr. Mr. Minner. In this appeal, we consider whether a self-insured government entity may subrogate heart and lung benefits against a third-party settlement received by a police officer under its employ who was injured in a work-related injury which did not involve a motor vehicle. Please proceed.
Good morning, Your Honor. Chief Justice, fellow justices, may it please the Court. I'm Stephen Robner. I represent Ms. Tiano. I'm here today with David String from my law firm, who's co-counsel on this case. This is not factually, we agree with basically on all of the facts here. Ms. Tiano was a police officer in Philadelphia injured in the line of duty when she investigated a motor vehicle crash, but this is not a motor vehicle case. She came on the scene afterwards, and she was injured when she stepped in a hole left by PICO at the property. That's not really in dispute. What did happen is there was a third-party case, and PICO settled that matter with us while she was receiving heart and lung benefits, which were not workers' compensation at the time. And the confusion is that this court, in the cases of Oliver, Bushta, Topolsky, Annunziato, Sturmel, Alpini, has made various decisions over the last 20 years relating to heart and lung benefits and workers' compensation benefits that all involve motor vehicle cases. So this, in a sense, is a case of first impression because this is the only case that has involved non-motor vehicle injuries, which we stipulate, the facts stipulate to that. And not only is there no issue about the facts of the case and that motor vehicle, it doesn't arise out of or relating to a motor vehicle accident, like in the Alpini case where they expanded motor vehicle accident to include dram shop where there was a motor vehicle accident. She was injured, and in receiving heart and lung benefits, there was a distinction. There's a distinction in all of the cases that the court needs to realize, and that is that, and all of the cases do realize this, heart and lung benefits are not workers' compensation benefits. Two completely different things. But all of the cases and all of the reason that these cases have made it to the Supreme Court, they all deal with the fact that the courts, since heart and lung benefits were enacted by statute in 1935, the courts have basically said that because both cases involve an injured employee, even though I'm going to discuss that in a second, but because they involve injured employees, there's an overlap. And the cities and municipalities that we're dealing with in this situation and in most of these other situations have always tried to include the workers' compensation benefits as being the same as heart and lung benefits. And even in this case, where the city of Philadelphia wants to call Ms. Tiano's benefits workers' compensation benefits for the medical bills that were paid and some of the wages that were paid, because there really is not much distinction in the fact that there's no right to subrogate workers' compensation benefits. The law is pretty clear on that when it involves a motor vehicle accident.
But counsel,
Yeah.
and this is, I think, the question. Do you, since at least 1962, there has been at least a common law right for employers to get subrogation against third-party recoverers for heart and lung, correct?
I don't necessarily agree to that, but there's been allusion to a common law right. There's been a right to recover workers' compensation benefits.
You don't think this court has established a subrogation right or has recognized a common law subrogation right
for
heart and lung benefits?
There was one case that said it. So the main case, the Topolsky case, Topolsky does not mention heart and lung benefits in its opinion whatsoever. It says there is a right of subrogation, but it doesn't say what they're subrogating. We think it's heart and lung benefits because in Topolsky, the injured police officer who was riding the motorcycle, I lost my train of thought there for a second.
Well, okay, let me change that.
But basically, he received full benefits, which would be heart and lung benefits.
Tell me why common law subrogation wouldn't apply to heart and lung benefits.
Well, so first of all,
common law subrogation is basically I have a duty to pay, but it's somebody else's fault. I should be able to go after them to get those benefits, to recover what they're obligated, what I had to pay out due to no fault of my own, but their fault. That's common law subrogation. Why should that not apply to heart and lung?
Because Ms. Tiano, as a first responder, and this would apply to all first responders, is at a different level than a regular employee who's injured. So the cases that have discussed this have said the heart and lung benefits are not to reward, but they're to protect and encourage people to become first responders, to take the risks that first responders take every day. We're here on September 11th. That's an example of when the heightened awareness of how important first responders are to our community today's the day that we remember that and we think about that. And in doing that, the courts have said that that the law up until recently was considering the employer's rights over the first responders' rights. And what we're saying and what the cases found is that, and this is in Sturmel, that the focus on the preferential treatment of injured employees, public safety employees under heart and lung, should be considered more importantly than the impact to the employer.
But Sturmel and Oliver and all those cases did not deal with, they dealt with statutes that expressly limited the right of subrogation. Here, you can't point to a single statute that limits that you're trying to employ that would limit the right to subrogation in a non-motor vehicle case for heart and lung benefits.
The legislature did not include anything about subrogation in a heart and lung case. That's in there.
There's no statute that limits the right of subrogation.
There's no statute that limits it, but so what happened is everyone said there was a right, there was a common law right to subrogation. Then workers' compensation added the right to subrogation in the workers' compensation law.
Or codified the existing
right, and they codified it, and the Motor Vehicle Code did not include it. They said there's specifically no right of subrogation, and then they threw it into Act 44, basically, and gave it back.
All those provisions in the Motor Vehicle Financial Responsibility Law are not at play here. So my question is, what statute are you relying on to limit the employer's common law right of subrogation in this circumstance?
I think the cases are very clear that they're very unclear that in Topolsky, and I think that's the only case really, and other cases followed that, where they said there was a common law right to subrogation. I think they missed the mark. I don't think that they said they didn't.
So I just want to make sure. You're not saying that there's any statute that limits it. You're asking us to rule there is no common law right to subrogation for heart and lung benefits.
Correct. That there's no right to subrogation.
You want us to overrule Topolsky?
Yes.
Yeah,
and I think the cases have already done that because Topolsky was a motor vehicle case, and by the findings of Bushta and the other, and Oliver and Sturmel, that case would come out differently today.
Counsel, you brought a claim against PICO. In the context of that claim, did you make a claim for medical and wage loss?
We made claims, but the claims were settled.
Well, I'm just asking you, is that part of your case?
We made claims for anything that was owed at the time. The settlement did not distinguish what the settlement represented.
But you were able to claim medical payments and wage loss?
We were able to claim, we claimed everything, yes.
Okay. Which was paid by someone else?
Correct.
And so, assuming you collect all of the wage loss and medical benefits and somebody else paid those in the first instance, isn't there a right to subrogation on the part of the person who paid them in the first instance?
Well, there would.
Otherwise, there's double recovery. I mean, I hate to use that phrase in this context, but that's precisely what happens. I mean, and this is sort of my rule of thumb on all of these cases as we look at them. I mean, there's really a reason for why there is or is not subrogation. There is not subrogation if you cannot collect the work loss and the medical benefits, motor vehicle accident cases, and when you can collect those in your third-party claim, then the payor of those in the first instance gets it back. And why wouldn't that be the rule here?
Well, I think the courts have been very clear in all of the recent Supreme Court decisions of the last 20 years since Topolsky that we shouldn't be looking at, they've said it would be error to look at the impact on the employer over the employee, the public safety employee. And in this case, that's the situation here. This is a situation, heart and lung benefits are for temporary disability. At the time the case was resolved by settlement, it was still a temporary disability. It became a permanent disability in May of 2020, so a few years later after the incident had happened. But there wouldn't be any, I think the country and the policies, the public policy interests have moved forward, especially in light of cases like Bushta, that with heart and lung benefits, there should not be a right of subrogation across the board. And the fact that Topolsky found that.
The first responder gets to retain monies that were paid by someone else, because it's essentially what we're talking about in the purest sense.
They get, well, in settling a case, there are other considerations.
Well,
one of the considerations is that...
There are, but I mean, the fact of the matter is, when you make a demand, settlement demand, if you went to court and you tried the case, you'd get all of those numbers on the board. They're awarded to you in full. You get to keep them, although you never paid them.
You don't know, well, we don't know if they go on the board until it gets to trial. So the issue is, this issue was unresolved at the time as well. There were some cases that were pending at the time, and our position is that there should not be a right of subrogation. So those numbers were arguably on both sides, whether they should count or not count, or what's going to happen at trial, and that's what makes a settlement. So if the numbers, if there was a right of subrogation, they would come on the board. Maybe the case would be worth more. This isn't the place to argue it, but that's all. That's what goes into a settlement.
And of course, after this case, you would know one way or another. And you'd have a very different case if you're going into settlement discussions and you have no monetary damage claims.
Correct.
Okay.
So.
I still don't understand why you're repeatedly invoking Bush. There's no meviferal in this case. Wasn't that important there?
Well, so the dicta in all of those cases is what's important. It's not a motor vehicle case. So
did you just say dicta is important?
Dicta is very important. Is very important. Yes. I don't know if I said it differently or not, but it's the finding of the cases were that the motor vehicle law precluded subrogation in a heart and lung case. But the explanations of how you get there, I think, is very important because it explains how far this court has come in the last 20 years in protecting the rights of first responders.
That's, I guess, at one viewing it through your lens, I guess. But the meviferal's anti-subrogation provision was what that turned on, right? It seems like you're in a different case here.
Well, it turned on the fact that the Act 44 only gave back the right of subrogation for workers' compensation and specifically did not include heart and lung benefits. But in explaining it, it talks about all of those cases. I'll just say all of those cases because it's the same cases. But they explain the difference between heart and lung and the difference between workers' compensation, that heart and lung is for a temporary injury, workers' compensation is for the permanent injury, and then how the benefits change when it becomes a permanent injury, like we have a specific date in this case. When Ms. Tiano was permanently disabled, it becomes a whole different element at that point. But then the cases talk about I guess that there's an overlap, but there's no equivalency.
But all of those, to Justice Weck's point, what you call as dicta,
correct,
is how we justified the construction of the statute. It was a statutory construction exercise in those cases. We actually had a statute that talked about limiting the right of subrogation or extending the right of subrogation, however you add. You want to use the principles that we applied in construing a statute favorable to law enforcement first responders as a general principle to get rid of subrogation altogether for heart and lung benefits. That's a pretty big jump.
I think we're halfway there. I mean, I understand there's a statutory analysis that gets you there for the motor vehicle cases, but there is no statute at all for heart and lung benefits.
I think Justice Bronson put much more articulately what I was trying to express is I guess without viviferal, why doesn't the default rule favoring subrogation kick back in here?
Because he doesn't think there should be one.
Well, I don't know that there is a default, though.
You don't think there is?
I don't think there is. I think Topolsky was overturned with the recent decisions. I think Topolsky may not have even been a heart and lung benefits case. The benefits that were received look like they're heart and lung benefits, but Topolsky doesn't say it's a heart and lung benefits case. It's a police officer who's injured, who's receiving full medical and wage loss, which would be heart and lung, but the courts at that time were treating workers' compensation the same as heart and lung benefits, and they were treating that for subrogation as well. And I think that's why we don't really know what Topolsky was at the time, and the ultimate finding there was overturned.
Mr. Roffner, do you want to wrap up?
I think that covers everything.
Okay, thank you.
We rest on our briefs.
Thank you.
Thank you,
Let's
Chief
hear
Justice.
from Ms. Graff.
Thank you. Good afternoon, Madam Chief Justice and Honorable Justices. May it please the Court. I'm Andrea Graff, and I represent the wonderful City of Philadelphia in this case. This Honorable Court tasked us with two specific issues. First, we're to address the underlying decision of the Commonwealth Court allowing for subrogation of heart and lung benefits to ensure that it does not conflict with, I'll use, quote, the cases that we've been talking about here. Second, we are tasked with explaining whether subrogation exists under Section 319 of the Workers' Compensation Act and Topolsky in non-motor vehicle cases, which again, we are all in agreement here, there is no motor vehicle case involved. The dispute lies with whether the employer's right to subrogate heart and lung benefits will continue here. And one distinction I do want to make is to hopefully make it a little less greedy. In this case, in all cases where this comes down, we are not seeking the full salary that Ms. Tiano received the entire time that she was out on heart and lung benefits. We are seeking the amount that she would have received under the Workers' Compensation Act. I believe in her year and based on her earnings, she was earning the highest weekly compensation rate for her injury year 2016. We are seeking only that amount. So let's just say that amount was $750 a week, and she was actually paid by the City of Philadelphia $1,000 a week. We are only seeking that $750 a week. So just to clarify that we are relying on Section 319, the Workers' Comp Act, and similarly situated, we are only seeking what she would have been paid under the Workers' Compensation Act specifically. I don't need to explain to your honors the reasons that we have subrogation as an employer's attorney, and I'm not going to bore everybody with those details, but I will bore everyone with the details of the distinction between subrogation with heart and lung benefits and the cases that we've been talking about.
Ms. Graff, after everything we've heard today, you couldn't possibly bore us.
I appreciate that.
Please don't try.
Okay, I won't. I promise I won't. I'm not paid to do that. But I will get into the nuts and bolts of Bush, Sturmel, Oliver, Annunziata, if I'm pronouncing it correctly, all dealing with very specific statute that disallows subrogation of heart and lung benefits. Here we simply do not have that. I will fully and wholeheartedly agree the Heart and Lung Act is silent on subrogation. It's silent in allowing it. It's silent on disallowing it. I deal with the Workers' Compensation Act and heart and lung cases on the daily in representing the City of Philadelphia. It is a constant, which are you referencing? How do you handle this claim? As I have adjusters asking me those questions all the time. How do I pay medical benefits in this case? How do I continue paying wage loss in this case? So they go hand in hand. So while the Heart and Lung Act itself could be absent on a specific verbiage, we do refer to the Workers' Comp Act consistently. So in this case, with Heart and Lung Act itself being silent on subrogation, we can turn to the workers' compensation case. And
why wouldn't you view it as, well, if it was workers' compensation and I wanted to answer the question whether there was subrogation, I would turn to the Act, the Workers' Compensation Act, and I would say, oh, here it says I can subrogate. But this is heart and lung benefits. And so why wouldn't you go to the Heart and Lung Benefit Act and open it up and say, there's no clause here that allows me to subrogate, so my assumption should be that I should not be allowed to. Why is it that you assume that you should be?
Respectfully, I'd say it doesn't disallow subrogation. It is silent on both sides, unfortunately, and that's what brings us here today. And the Heart and Lung Act is silent on a lot of issues that I deal with every day.
Aren't these the type of statutes that are supposed to be read in favor of the injured worker as opposed to again?
Yes, and especially the Heart and Lung Act in favoring those who take these jobs that personally have to be so difficult day in and day out, and they are, by way of greater salary, by way of being on those temporary benefits for a longer period of time. They're subject to raises, they're subject to all those sort of things while they're on heart and lung benefits. But again, to use a term that I don't like to necessarily use, the Heart and Lung Act isn't permitting a double recovery in terms of when somebody has a third-party recovery.
Counsel, as Justice Mundy just said, when these statutes were written, the policy behind it was clear. Subrogation in the motor vehicle, silent in the heart and lung. Why do you just not read the statute in favor of the claimant to say the General Assembly wanted first responders to benefit a little bit if they're injured under heart and lung?
Respectfully, and nothing against injured workers or any or first responders, that subrogation is still paramount with what we do, and that double recovery shouldn't be allowed or encouraged.
So we should let third-party tortfeasors continue their negligent acts in the Commonwealth, because nobody's going to bother to send the suit against PICO so that they'll fix the hole in the middle of the grass so it'll remain there for the next police officer to trip into.
I disagree, because there's other damages that could be sought in the PICO case that can't be sought under workers' comp or heart and lung, so there is still the carrot for the injured worker to go after in that regard.
And the subrogation, the limited subrogation that is allowed under workers' comp has not discouraged third-party suits. We still have subrogation claims in third-party suits. I mean, I don't know. I guess the question is, does the Heart and Lung Act, by its silence on an affirmative right to subrogation, abrogate the common law right to subrogation?
And I disagree, as it doesn't disallow subrogation, and the policies, again, I'm not going to bore anybody with why we have subrogation to begin with, are read into, I believe, and applied to the Heart and Lung Act.
Any other questions? Ms. Graff, have you argued before our court before?
I have not.
Well, welcome.
Was it obvious?
No.
Not at all.
No, we just hadn't seen.
And I wasn't bored at all.
My client's here, so please.
No, I was just going to say.
You did a wonderful job.
You did an excellent job on behalf of your client in your first argument, and Mr. Rovner, you too. It's always good to see you. Thank you both.
Thank you, Justices.
Thank you.
Good afternoon. This case arises out of a traffic accident in the city of Philadelphia in which a car was struck by a New Jersey Transit Authority bus. The car's passenger, a resident of Philadelphia, sued the New Jersey Transit Authority in the Philadelphia County Court of Common Pleas, and the Transit Authority sought to have the suit dismissed, contending that it was an arm of the state of New Jersey, and so was immune from suit under the 11th Amendment to the United States Constitution. The lower courts rejected this claim, and we accepted review to address the propriety of their decisions. Please proceed.
Thank you, Madam Chief Justice, and may it please the Court. Justin Danilewicz from the law firm of Saul Ewing, LLP, and I'm honored to appear before you today on behalf of the defendant appellant, New Jersey Transport Corporation. I'd also like to take the opportunity, if I may, to introduce my client, Deputy General Counsel of NJT, Mr. Michael Rowe.
Welcome.
The sovereign immunity of states, and equally the arms of the states, is of fundamental importance to our federalist system and our constitutional order, with few exceptions, none of which are present in this case. States are immune from suit in foreign jurisdictions. Absent those exceptions, and absent a state's consent to be sued in foreign courts, hailing any state into the courts of a foreign jurisdiction is unconstitutional. In this appeal, which raises an issue of first impression for this court, New Jersey Transit asked this court to give full expression to its sovereign dignity by reversing the erroneous decision of the Superior Court below. The Superior Court erred in several ways, most importantly by failing to give deference to the sovereignty of New Jersey and by failing to correctly identify New Jersey Transit as an arm of the state, a public entity, as numerous courts have consistently found, but most importantly, New Jersey's highest state court, the New Jersey Supreme Court itself, has found. And in that respect, it was clear error for the for the Superior Court in this case to fail to reach the same conclusion. The court granted aliquota on a number of different questions, and I'm happy to take the court's questions on any of these issues, but I think most importantly, the Superior Court below completely ignored its prior decision in Flamer versus New Jersey Transit. It also failed to give due consideration, although citing the case, to the Carnes case by the Third Circuit, which is compelling persuasive authority that indeed New Jersey Transit is an arm of the state. The Superior Court opinion also erred in failing to properly apply Chief Justice Todd's opinion in Goldman, a case that, notwithstanding very important factual differences from the facts in this case, laid out a helpful framework for analysis of what constitutes an arm of the state for purposes of state sovereign immunity. And finally, by failing to defer to New Jersey State's own statutes and its own highest state court's consideration of what constitutes an arm of the state, the Superior Court below erred fundamentally in failing to follow the instruction of Justice Thomas in Hyatt 3, which reversed Nevada versus Hall, as this court is aware, and changed the comity analysis to instead requiring that courts considering the suit of states in foreign jurisdictions give full weight, full constitutional deference to the recognition of sovereignty of those states.
Counsel, after Hyatt 3, should we be looking any further than New Jersey's own statement of its view of what the New Jersey Transit Authority is? I mean, there's a statute that specifically calls it an instrumentality of the state.
That is exactly correct, Justice Donoghue. I think you need look no further than that. And that's, of course, the key distinction between this case and Goldman. Goldman, although setting out some helpful factors, considered intrastate sovereignty. In this context, where we're dealing with interstate sovereignty, I think you hit the nail on the head. The place to begin is by giving due consideration and deference to the opinion of New Jersey's highest court, as well as the statutes of New Jersey. In fact, I think it would be safe to say that even under the discredited Nevada versus Hall comity analysis, that's where this court would begin, by giving due consideration to our sister states' evaluation of those issues. And so the court really need go no further than that. Once, of course, this court has determined that New Jersey Transit is an arm of the state, as I feel respectfully this court must do, then I think it's a relatively easy step at that point under Hyatt 3 to conclude that this court must recognize New Jersey Transit's sovereignty and that it's improper to hail it into the courts of the Commonwealth.
Pardon me, could I ask you, since you just mentioned the arm of the state thing, how did that even become an issue in the case? Because it doesn't seem to me Galette ever questioned whether New Jersey Transit's an arm of the state, and they've continued not to address that issue. How do we resolve? They're not even addressing it.
That's correct, Justice Wecht. The New Jersey Transit itself raised the issue immediately in its answer to the complaint, and then made a motion to dismiss on the basis of sovereign immunity the status of New Jersey Transit as an arm of the state of New Jersey. And then the Superior Court resolved the case on that issue. Although we briefed it below, Galette did not brief the issue at all, as you point out. And notwithstanding the lack of any argument on the issue, the lack of full briefing on the issue, and essentially the waiver of that argument, I would argue, the New Jersey Supreme Court nonetheless, notwithstanding its prior decision in Flamer, notwithstanding the factors in Goldman that compel a contrary decision, reached the mistaken conclusion that it is not an arm of the state.
What's your waiver principle? If you had the burden, you made the argument, you briefed it, and you're saying that if the other side doesn't brief the issue, you win and the courts don't look at the merits because by not responding, they waived your argument?
Correct, Justice Probst, and I think that's right. I mean, that's typically my understanding of the way waiver generally works. We, at every opportunity, raised the issue.
Right, you raised it.
Correct.
I'm just trying to figure out how, I mean, if a party doesn't file, if a responding party in an appeal doesn't file a brief, we don't issue an order that says the appellant wins. We look at the issue and make a decision.
And by no means am I suggesting that the court shouldn't look at the issue.
Maybe she should be stopped from arguing it if she hasn't briefed it, but that doesn't mean you get an automatic win.
No, I'm not suggesting we do. And I think, to the extent that I was misunderstood, let me clarify that I think that there is sufficient material in the record for this court now to conclude, notwithstanding what was or wasn't argued below, that there's simply no question here that New Jersey Transit is an arm of the state of New Jersey.
In a post-Hyatt world.
That's correct, Justice Wecht, absolutely. In fact, I think this case is very close to Hyatt, because as the court knows, and as Justice Thomas summarized in the Hyatt 3 opinion, that involved a claim by a Nevada citizen against California Tax Board in the state courts of Nevada. And it was exactly in that context that Hyatt 3 held that the previous approach to comedy had to be abandoned, that it was unconstitutional, that sovereignty is not something that is granted to other states as a matter of grace. It's a matter of constitutional requirement. It is that basic and fundamental. I think that it's instructive that in overruling Nevada versus Hall, the facts of Nevada versus Hall, again, very similar to the facts in this case, where you had California citizens injured by a Nevada driver employed by the state of Nevada, brought suit against that Nevada citizen in California. And the court at that time, in an opinion by Justice Stevens, held that as a matter of comity, the case could be decided. That is totally discredited, and I think that's sort of the direction the Superior Court was going in the case here before us today. I think that the statutory factors in this case are incredibly compelling in terms of, as was pointed out before, the description of New Jersey Transit as an instrumentality of the state, as exercising public and essential government functions. But that's not all. New Jersey Transit is absolutely, thoroughly, and totally overseen in very strong ways by the governor of the state of New Jersey, the governor's appointment of the vast majority of members of the board of New Jersey Transit. New Jersey Transit has to conduct an annual audit and provide the results of that audit to branches of New Jersey state government. No action of the board can be taken without approval by the state of New Jersey, and the governor can veto any action taken by the state of New Jersey. All of these are incredibly strong factors, but there are more. The fact that New Jersey Transit has the power of eminent domain that it can exercise under the statute. It has essentially a police force that is empowered to exercise police powers and duties throughout the state. So I think for all of these reasons, there is simply no question as a matter of statute that New Jersey Transit is an arm of the state. And consistent with that, the New Jersey State Supreme Court in the Muhammad case, which we cite on page 20 of our opening brief, concludes in the same way. Of course, New Jersey is not the only state to reach that conclusion. On page 9 of our reply brief, we provide a string cite to numerous cases. There are New York cases, Pennsylvania cases, and others that reach the same conclusion of arm of the state. And so for all of those reasons, I think that this court is compelled respectfully to conclude that New Jersey Transit is an arm of the state of New Jersey and must be given sovereignty. I would conclude, just to be succinct, and I realize the hour of the day, by noting that if this court were to disagree with the state of New Jersey, this would be a particularly inappropriate posture to do so, because there could be nothing more problematic or more ironic and frankly improper than for this court, in a case of first impression about deference to a foreign state and sovereign immunity, to take a completely different position than the position New Jersey itself has taken through a decision of the New Jersey Supreme Court. I'm more than happy to answer other questions from the court, but if not, I can also sit down.
Any questions from the justices? All right, thank you, sir.
Thank you very much.
Hear from Appellee's counsel, Ms. Gabriel.
Good afternoon.
Good afternoon.
Olivia Gabriel for Galette.
Could you pull the microphone down?
Yes.
I think your opposing counsel was slightly taller.
Thank you. We do not disagree that New Jersey Transit is a public entity, looking at the statute. However, we don't believe that should end the inquiry. Looking at the statute, we still have to determine whether or not New Jersey Transit is immune, and we don't believe that they are. In New Jersey, immunity is determined by the function performed.
Wouldn't that issue be decided by a New Jersey court if we were to?
Yes, by New Jersey court and also New Jersey statutes. If we look at the function performed, there are two different functions. We have to determine whether or not the function is ministerial, whether or not it's discretionary. And we believe bus drivers are ministerial, and the definition, an act is ministerial if it is one in which a person performs any given state of facts in a prescribed manner in obedience to the mandate of legal authority without regard to or exercise of his or her own judgment.
Counsel, how does that address the 11th immunity problem you have? I mean, Hyde 3 makes clear that states retain their sovereign immunity from private suits brought in the courts of other states. I don't see how that act gets you around that problem.
We don't agree that the 11th Amendment applied here because the case was not in federal court. So we only agree that we have to look at New Jersey statute and case law. And if we do that, then we have to look at what function the employee had, and based on that to determine whether or not it's ministerial or discretionary. And we believe that the bus driver did not have any discretion, and based on that, they are not immune.
You may win that. You may win that point in a New Jersey state court, but the question we have here is whether you can bring that action in a Pennsylvania court. And I mean, I think that really has to be our 11th Amendment focus here. I mean, I would disagree with the argument you're making in terms of how New Jersey's Tort Claims Act works. It's probably exactly right.
Right.
And if you're in a New Jersey court, that's an argument, you know, to be made. But the problem is, it would appear, unless you can distinguish the Hyatt rule from where we are here, it would appear that Pennsylvania is not able to hear that case.
Well, we believe that under Hyatt 3, that we have to look at the law of New Jersey. And if we do look at the law of New Jersey, then that's the result.
But your act, and your New Jersey Act does not contain any language in which arms of the state of New Jersey explicitly consent to being sued outside of New Jersey. And that's what our Commonwealth Court held in the Marshall case, which you don't even cite in your brief. You don't mention it ever in your brief. How can you deal with that?
Right. I mean, we believe that we agree with just Hyatt. We agree that under Hyatt 3, that if we look at the law of New Jersey and apply the law of New Jersey, and then we can determine whether or not New Jersey transit is immune.
But you're looking at the law of New Jersey dealing with immunity from suit for the claim.
Right.
The law of New Jersey we're looking at Hyatt is, what does New Jersey law say about what this entity is in terms of an arm of the state?
Right.
The New Jersey tort claims law doesn't relate to that. You have to look at New Jersey law that created the transit authority to find out what it is. So I'm kind of in this situation where I think you're looking to the right state's law, but you're not looking at the right state law. Do you know what I mean?
Right.
So what do you say about how the New Jersey Transit Authority is organized? How is it created? How does it operate? What does New Jersey state law say, not about whether it can be sued, but about whether it is or is not an arm of the state?
Right. I mean, based under Hyatt, as I previously mentioned, we believe that, yes, it is a public entity, but we have to look further based on what the law says.
And what's that further law say about what kind of entity it is?
We believe it is a public entity, but we don't believe that it is immune.
You know, that's the disconnect, because, I mean, not only Marshall held to the contrary, but the Appellate Division in New York held to the contrary. And you don't cite that either, Nizamov case. I'm not understanding how you're getting around. Well, let me put it this way. I'm not sure I understand why you say Hyatt 3, if I understand what you're saying today, has no bearing here. I mean, it's a command under the Supremacy Clause.
Well, I'm not saying it doesn't have any bearing. I'm saying that we agree with it. However, it leads us to look at New Jersey law, and when we look at New Jersey law and we examine New Jersey law, we don't believe that they are immune.
Any other questions for counsel? No. All right. Thank you both very much.
Thank you.
Mr. Minner, I wanted to say thank you to you, to our court crier, of course, to our prothonotary, Caitlin Gorman, and to our court security for looking after us, Gary Shovlin, John Evans, and Scott Town, and along with the Philadelphia police officers who are so helpful to us. Also want to thank PCN for broadcasting our argument sessions as an educational service to the Commonwealth. Mr. Minner, you may adjourn court.